One, yes, CMPL means dismiss for default my lord SCJ and my lord Roman my lord. Very urgent matter, my lord. Petition is to go to repair my lord. Or no branch is there, so next bench or no dismiss for default CMPL by this bench.
CMPL.
Dismiss for default my lord. Restoration.
CMPL is restored. Give you a slip, it will be listed.
My lord, my kind to listed name, just next sitting my lord.
Why did you allow your case to be dismissed? All right, it will be listed soon.
Content to mention one content matter. One content matter. Single bench content matter.
Single bench.
Content matter.
So more than 1,000 single bench contempt matters are already there on board.
So why? Because the order was the decision is taken.
All right.
No course of action shall be taken against me. And decision has been taken after expiry of the stipulated period. So I have filed a contempt.
Not now. Not now. So all the matters will be taken up. Give the slip to Mr. Who has violated.
Secretary SME.
All right, we will see later. No, not now. Let me have some control over the whole pending matters. Make a mention after some time. Yes. Not now.
The submission item number 1.
May please, my lords. So, due to the inadvertence of the petitioner who was appearing in the writ petition notes, the defect was not removed. In the meantime, the defect has been removed. The case was dismissed for non-prosecution due to non-removal of the defect, while your lordship's order dated 16/1/2020.
CMAPL.
CMAPL. I was only humbly praised.
Removed now.
Defects are removed.
It has been stated by this application has been filed for restoration of surrender, which is to dismiss for default for non-compliance of preemptory order. Preemptory order.
So,
For not removing the defects as pointed out by the stamp reporter. And senior counsel appearing on behalf of the petitioner states that the defects have since been removed or stopped. In such view of the matter, in the interest of justice, the application is allowed. Let so and so be restored to its original file. Yes.
I have a humble prayer note subject. I have a humble prayer note subject to lordship's kind consideration. Let the writ petition be listed before the
Make a mention later.
Or orders item number 2. Well, I have filed this application for recalling that order. On the basis of the statement made by my friend, your lordship disposed of, but that judgment is on a different point and different case also, my lord. That was a case, my lord, where the
File a review application.
No, on his statement, this matter was disposed of, that this covered by that judgment is not covered by that judgment.
File a review application. It is not notification.
No, I have called for file an application for recalling that order, my lord, because it is on the wrong statement made by my friend, this order was passed.
All right, file your affidavit.
My lord, I will file affidavit, but your lordship may see the IA which he has filed 7651. The affidavit is so.
Mr. Counsel, you have filed IA in this application.
Yes.
Sorry.
I'll file a review application, my lord.
All right.
My lord.
I'll say
And
affidavit
for the petitioner seeks permission to withdraw IA number so and so with the liberty to file a review application seeking review / recall of the order dated 5/5/2024 or stop. Is IA number so and so stands disposed of accordingly with the liberty as sought.
All right. Permitted, your lordship, pardon to mention item 204 and 215, 215, may permitted to no instruction.
20
4 and 215.
115.
The petitioner doesn't want to proceed with the contempt case, your lordship.
My lordship's permission, my lord. One matter item 833, my lord. That is an urgent matter when the petitioner is out of service since 2021.
Contempt matters are.
My lordship's permission that letter to next week or top of the list. For that,
I don't know. 611, my lord. Comply.
What's pardon to mention?
611.
Item number 189. Order has been complied. Public.
Order to mention or also the phrase content matter not listed till.
Please wait for some time.
Item number 707.
Not today, later.
That's item number 707 complaint. 707. Seven has been passed.
717.
707, my lord.
70. Any other case where the order has been complied with? Any other case where there is no instruction? All right. Yes.
Item number 1.
Item number 1, please, my lord. Then, my lord, on last occasion under the order dated 28/6/2024, the lordship has observed that if by the next date the order is not fully complied with, the VC of the Vice Chancellor of the University will be required to be present in the court on the next date. My lord, today my senior has served me a copy, my lord, copy of the show cause affidavit. And my lord, I need to take some instruction, my lord, may keep this matter next Friday.
Why when the order has been complied with?
Because then my lord, the order in the requisition was the dismissal order was set aside and a direction was given. Direction was given to reinstate the petitioner in service forthwith and all the consequential financial and service benefits as due and admissible to him be granted within a period of 3 months. They have provided the show cause affidavit, my lord, just now I have gone through it. And my lord, in page 8 of the show cause affidavit, they have disbursed my arrear salary amounting to rupees 71,54,095. But the other consequential benefits, my lord,
You can claim, I'll give you that liberty.
but it has not been, my lord,
I'll give you that liberty that if some consequential benefits are still required to be paid, that shall be paid.
but my lord, only one submission, my lord, that has not been fully complied, my lord.
See, the order was violated after completion of 3 months from the date of the order.
My lord,
All right. So they have complied with the order now after 9 years.
my lord.
You may be right in your submission, but this 2015 contempt matter, nothing has been done so far, therefore.
My name David Napier there, despite filing of local government. Moreover, my lord, I have already submitted the copy of the so-called notice, my lord.
See, you don't have any defense.
No.
You don't have any defense. You can be convicted right now.
My lord,
All right.
My lord, I only pray for next week, my lord, go on senior.
Unnecessary. The compliance affidavit has been filed on behalf of the university in the light of the observation made by this court in the order dated 28/6/2024. So it is the stand of the university that this court's order dated. What is the date?
My lord, the
Court's order dated
28/6.
5/2/2015.
28/6? No.
5/2/2015, the writ petition order.
5/2/2015. Passed in WPC.
Yes, my lord.
WPC number what?
2679 of 2010, man.
2679 of 2009 has been complied with, and the petitioner has been granted consequential benefits arising out of washing off the order of dismissal which was passed against him. So stop. It has been stated at a sum of rupees 72 lakh.
71 lakhs, 71 lakhs 54,095, my
71
lord.
lakh and odd
Annexure
has
D.
already been paid to the petitioner as areas of salary. Full stop. Learned counsel for the petitioner has vehemently argued that the court's order has not been fully complied with, as all consequential benefits have not been given to
No, not, they're not given.
the stop. Be that as it may, considering the subsequent development, and since the contempt petition is pending since 2000 15 without any action against the contemners, I deem it fit to drop the contempt proceeding with an observation that the petitioner shall be at liberty to raise his grievance before the Vice Chancellor of the university, claiming specifically the consequential benefits which have not been allowed to him despite this court's order, other consequential benefits, rest of the consequential benefits. So stop. Land Council for the university has assured that if the petitioner approaches the Vice Chancellor with his specific claim, the same shall be considered in right earnest and decided right earnest, and his grievances, if any, shall be redressed. Yes.
My lord, only one prayer, name of Mr. Esbrijana for petitioner may be reflected.
All right. Eight.
Item number 8.
Right.
PDS always there to be taken.
Yes.
Item number 8. Item 8 under the university, must last at manage directed giving liberty to comply with part of that order. I claimers next to it, in the process, we have already processed the file release of the salary component during the suspension period. Must I place setting the style matters at the process of the job, process is going on matters.
What was the order?
Order was managed to comply, to give the retirement benefits and all these things.
Ah.
Must their matters directed, last time matters directed that yes, you are not giving them the salaries for the period of suspension. But your matters directed that yes, this amount will also be released. Not directed, that's so fine. That matters so far that retirement benefits that has been complied with. So far that salary component, that should be managed complied with, that is what matters observation. As per matters super delay,
Petitioner. Who is for the petitioner?
so the council is not there, matters.
Someone appears on behalf of the petitioner. And counsel appearing on behalf of the university states that the what?
Retirement benefits so far you have been told, so far that area salary component during suspension period, that will, the process is going on, and it takes 7 days time minutes to.
That the areas of salary which the petitioner is entitled to shall be paid within 1 week. Stop, place this case 1 week as the first case. You can caution your office.
I have already managed, I have already communicated matters here.
Item number 2.
So in item number 2, your lordship has directed personal appearance of Tahsildar, he is present. What has happened, my lord?
Whether order has been complied with
Yes,
or
that
not.
has been complied.
Let me see the
I
order.
am
first.
just placing the facts before your lordship.
My lord,
What has
item eight,
happened?
My lord,
A particular piece,
my lord, item 8, I got disconnected, my lord.
Yes, let me see the order first.
to provide the case record of a mutation case.
Let
That
me
was
see
the
the
order.
order first.
Yes, ma'am.
Where is the order?
At least 7 of the content bits somewhere.
7, yes.
Well. Specific direction was given to supply the mutation, copy of mutation case number 1203 of 93. Madam.
Yes.
Within a period of
Just a minute.
Madam.
Yes.
I may be permitted to.
Yes, please.
A particular piece of land was purchased by 6 persons by means of a particular registered salary. One of them filed a mutation case suppressing the fact that other purchasers are there and got her name mutated. And my learned friend clients is another purchaser under the same salary.
Huh?
So,
Land and client?
is another purchaser under the same cell deed. There is a particular cell deed, there are 6 purchasers. One purchaser's what she did, she fraudulently filed a mutation case and got her name recorded in respect of the entire land, ignoring other 5 purchasers. My law and plan client is one of the purchasers. So he filed a writ application before your lordship that mutation case record certified copy may be provided to me so that he will file appeal before. And in fact, he has filed appeal before the sub-collector against the order of mutation by virtue of which one of the recorded owner has got the patta in her name. And that at this stage, your lordship has directed that mutation case record certified copy be provided to him. That is the order. The subsequent event is that the appeal which he has filed before the sub-collector, with the entire record of that appeal, sub-collector has set aside the order which was passed in favor of one of the purchaser, ignoring my learned client's claim. That order was set aside, and in the meanwhile, by virtue of that order, the patta has already been corrected. So his grievance has already been redressed. Now the question is, we have directed to produce the certified copy of the record. We have given affidavit before your lordship that muted appeal record is available. The entire, he was the appellant, he got the appeal allowed, but he has not placed it before your lordship. That appeal was allowed on contest.
When was the appeal filed?
Yes, my lord. That appeal was filed before filing of the writ petition. It is abhorring the writ petition. That appeal was filed at para 8. That your lordship may see my show cause. Paragraph 3 may kindly be seen, my show cause.
Yes.
That as has been narrated in the writ petition, the petitioner was agreed with the order passed in mutation case number so and so by which the record of right in respect of the disputed property is mutated in favor of one Snehaprabha Das in an erroneous manner, although the said disputed property was.
Have you given him this?
Yes, I have.
When?
Just now, sir.
The court will proceed against you.
Just.
The court will proceed against you. You people are making mockery of the court proceedings.
No, my lord. Just they have copy, my lord.
You examine, and next day, if the court finds that the stand which has been taken is correct, the court will proceed against you, your client.
No, they are suppressing the. I will. Yes, I will objection, my lord.
You do that.
Yes, ma'am.
So-called reply has the Tahsildar so and so is personally present in court pursuant to this court's previous order. A so-called reply has been filed on his behalf, which has been taken on record. Stop. List this case on 1B. Stop. It prima facie appears to this court that the petitioner has been misleading this court from the very beginning. So stop. If the court finds the same to be correct, the court will consider initiation of appropriate proceeding against the petitioner on the next date.
Item number 3.
I may be pardoned, your lordship, my lord.
And you will not, the court will not allow you to withdraw the contempt petition.
I may be
Well, I will
pardoned.
file only lord. Grant time to file objection, my lord. They have not yet completed the order, sir. They have not issued the certificate, my lord.
They will not give.
My lord.
They should not give.
Personal.
And after intervention by your lordship, they have now they are saying, my lord.
Mr. Counsel,
My lord.
the court has given you time to deal with what has been stated. So you file your reply. If the court is satisfied that you have been misleading the court from the very beginning, the court may initiate contempt, not contempt, criminal case against you.
But George, not they have served. I will examine.
No, let us see. Let us see. That will depend on the stand which you take later.
I may be pardoned, my lord.
Number 3.
My lord, I may be pardoned. I'm appearing on VC, my lord.
This item number.
My lord, may please your lordship. Your lordship kindly have a glance on order dated 28/6/2024, passed by this honorable court, your lordship.
Yes, what about the order?
Yes. The order place.
The order is page 72, your lordship.
at annexure 6.
So whether order has been complied with or not?
No, your lordship.
So cost
ଅଛି ଅଛି।
What was the order? Let me see.
7. The operative portion is page 73, my lord.
Yes, whether Tahsildar has taken a decision.
Yes, my lord, Tahsildar, as per the order of the Honorable Court, Tahsildar has the basis of his claim is a decree passed by the civil court, ex parte decree. And the Honorable Court said that you take recourse to law or you record the land in favor of the. Tahsildar has filed appeal against that order, which is when the civil court decree on the basis of which he is seeking mutation. That decree is under challenge in regular first appeal before the district judge, and which is pending. I have filed the document to that effect.
So you could have disposed of this application.
Kindly in 2004, the civil court decree was in my favor. The judgment decree was passed. Appeal was filed in 2015. Yes.
Yes.
And she petitioner matter. Access the order path made the judgment path made the civil court substitute matter, and the civil right approved in favor of the petitioner cannot be taken away. Mere filing of the appeal doesn't mean that the appeal order is stayed, that civil court's order is stayed here also.
My friend may not be correct because appeal is a continuation of the suit. We are in appeal and the to us, if there is any error, then you can file appeal before the to state government, and accordingly you have filed appeal. If he can appear in the appellate court and dispose it of. If in appeal the state will lose the case, we will record your name. But basing on a decree passed by the lower court, which is challenged in the appeal, I think that is why the Tahsildar has not recorded. And appeal is that is the order of the court that you can take recourse to the higher forum. We have taken. We will dispose of the appeal as early as possible. Let my learned friend cooperate. He will appear before the district judge, and your lordship can write that if subject to result of the appeal, we will immediately record the time.
Your lordship, when the appeal is pending?
Yes, before the district judge Baleswar.
Since when the appeal is?
Since when?
Since 2015 years.
And you could have sought for an interim order.
I have no such interim order. And your lordship kindly had a glance on page note 50 and pressing page note 50, your lordship. That the civil court's judgment. For a moment, your lordship.
And when was the appeal filed?
In 2015. Reference number 281 of 2015. State versus Tirthacharana Das.
If your lordship kindly looks at page note 50, the civil court judgment, your lordship.
In a month.
No such order.
The court is initiating contempt proceedings.
My lord,
Whether he is present.
the Tahsildar is present.
All right.
My lord, within 1 month we will ensure disposal of the appeal, thereafter submit. Or subject
What am I submitting that opportunity as
or not?
Yes, Tahsildar is there online.
specifically directed to.
Yes, Tahsildar is there.
All right.
My lord, may I?
The court is framing charge against you.
My lord, may I submit one thing? Subject to result of the appeal, tomorrow we will record the name and
Sufficient of.
Yes.
When was this order passed? 17 to 2014.
we'll do it tomorrow, subject to result of the appeal.
Whatever, you should have done it.
Yes, tomorrow it will be done. It will be done tomorrow.
Friday.
It may come next week, we'll do in the meanwhile.
Tahsildar has joined the court proceedings. So, as requested on behalf of the Tahsildar, list this matter on. Next Friday.
Next, we will do it subject to result of the appeal.
Do whatever.
Oblige, Your Lordship. Item number 4.
Item 4, my lord. There was a direction to consider the representation of the petitioner. Even before filing of this first content, the order has been complied. Today we are filing the compliance affidavit.
All right. Though there is no representation on behalf of the petitioner, a compliance affidavit has been filed on behalf of the state.
The speaking order is at the
Is being filed on behalf of the contemners. To the effect that this order has been complied with, which of the contempt proceeding stands stopped accordingly.
The personal appearance may be disturbed.
Personal appearance of
The secretary.
the secretary. And so stands dispensed with. Yes,
item number 5.
Item number 5, Lord. After the lordship direction, the container is present in court.
Yes.
Lords, against the order of the Honorable civil judgment, writ appeal was preferred. Writ appeal was dismissed on the ground of limitation or delay accept. Against that, now the state government has been given permission to move the honorable appeals court. Lord. So, lordship done some time in was,
no, in the meanwhile, let him face contempt proceeding.
lordship, 2 weeks after, you will comply the order or
No 2 weeks, no 2 weeks, we have already violated. When was the writ appeal dismissed?
no, sir.
Please give the date. When was the writ appeal dismissed?
Dismissed in the 6/12/2023.
6/12/2023. So it's a clear case of deliberate disobedience.
After this was sought for opinion of the law department opined because only on the delayed access without going to merit the writ appeal was dismissed now. So there was an opinion by law.
Now, how can you stay the order of the court on the ground that you are considering to file an appeal?
That is, should have filed with my lordship and then come out the solution.
Yes. The court
Something of.
do it, otherwise,
Yes, yes, yes.
you do, that is up to you. If you don't do it, then I don't have any other option but to proceed against you. All right. As requested on the contender, so and so is personally present. Also, as requested by learned AGA, with this matter on 1 week for him to inform about the compliance of this court's order. Post op. What are you? What is he?
Engineer chief, I'm giving
The
the.
engineer in chief shall be required to be personally present in court on the next date.
Item number 6.
And pursuant to your lordship's direction, the collector has passed the order. Item 6.
Yes, complied with. The it appears that
Last order.
based on statement made on behalf of the contender that the collector, which place?
Cuttack.
Cuttack has passed the order in compliance of this court's order dated 5/9/2022. Dated passed in WPC number 15269 of 2022. Violation of which has been alleged in the present contempt application. The contempt proceeding stands stopped accordingly. Yes.
Similar, I am for the petitioner. Well, I may be communicated.
For the petitioners, I'll be at liberty to question the correctness of the said order before appropriate forum in accordance with law.
I am giving a copy of that order.
Item number 7.
If so advised. Yes.
May it please your lordship. My lord, as per in preference to the honorable court, my lord, the contender has complied the
Compliant.
order, my lord.
And the compliance affidavit also have.
Compliance affidavit has been filed in behalf of the contenders. Since the order has been complied with, contempt proceeding stands stopped.
The personal appearance may be dispensed.
Personal appearance stands dispensed with. Personal appearance of the contempt.
The, of the additional sub-collector from settlement office.
Additional cover. Yes.
Item 9.
I'm on VC minor, virtual mode minor.
Yes.
My lord, the order has already been complied. They have filed the compliance affidavit at flag B.
Compliance affidavit has been filed on behalf of the contender. A compliance affidavit has been filed on behalf of the contender. The counsel for the petitioner states that the order has been complied with. Contempt proceeding stands dropped accordingly. Yes.
Item number 10. Not the order dated 10/1/2023 has not been complied with.
Yes, your lordship.
Lordship may kindly turn to the order, my lord. That is operating portion is at page 12,
Yes.
paragraph 8, my lord.
Yes.
Therefore, this court is of the considered view that the impugned order dated 18/2/2022 under Annex 12 is unsustainable in law and the same is required to set aside, and accordingly the same is hereby set aside. Further, the opposite party number 1 is directed to consider the case of the petitioner in the light of the recommendation made in favor of the petitioner as well as the law laid down by this court in Dipti Ranjan Misra case, and keeping in view the provisions of OCS Rehabilitation Assistance Rules 1990 as amended in 2016. The decision be taken keeping in view the factual background of the present case. In the event the petitioner is eligible to be appointed Group C post and there is a vacancy, the petitioner be appointed against a vacancy within a period of two months from the date of taking such decision. Let the entire exercise be concluded within a period of 3 months from the date of production of certified copy of this order. The authorities are directed to act upon the production of the certified copy of this order. Thereafter, I filed the first contempt law.
Forget first attempt contempt. Which part of the order has not been complied with?
They have not complied with that till date. Not as they have never complied, not passed any order, not.
Your lordship, on 26/2024, a speaking order was passed, your lordship.
26.
20 June 2024.
Yes.
They have to give me a copy.
Yes, it has already been, I'll file a memo to the sir.
All right.
A copy.
It is stated by learned counsel representing the learned AGA representing the contender that this court's order dated 10/1/2023 passed in WPC number 977/9775 of 2022 has been complied with in as much as decision has been, an order has been passed by whom?
By the additional secretary to the government, your lordship.
By the additional secretary to the government, state government in the Department of
Forest and
Forest
and Climate Change Department.
Order.
Environment and Climate Change.
the order is in his favor or against him?
Against him, your lordship.
Against. So what do you want?
They cannot pass this order, Miller. Your lordship may kindly see the order. If they have submitted that order, your lordship may kindly see the order. They cannot act as the appellate authority of the order of this honorable court. They are here, Miller. They have indicated since the divergent views are available and judicial decisions are available against this decision of this honorable court, therefore we are not implementing. They cannot do that, Miller. And this honorable court has specifically directed, consider his case, and if the vacancy is available and he is eligible.
No, madam.
No, your lordship, it has been decided as per Rule 7 of the OCS RA Rules 1990, your lordship.
No, the court had directed
Yes, your lordship.
that you do it in accordance with Dipti Ranjan Mishra case.
They are saying,
Just a minute.
Dipti
Dipti Ranjan Mishra case.
Yes, and keeping in view with the provisions of the OCA RA Rules 1990, your
All
lordship.
right. Keeping in view the provisions of OCA rules.
Yes, your lordship.
File as suppose we'll see.
I will show us.
4 weeks time is allowed for the contenders to file a suppose reply. As to why contempt proceeding be not initiated for deliberate disobedience of this court's order. Dated 10/1/2023. Just think of the situation that the order was passed in January 2023. In June 2024, you passed the order.
Reshuffle also
Your
dismissed.
Lordship, the personal appearance of the secretary may be.
No, personal appearance not now. Personal appearance will not be dismissed.
Attorney level.
Some 11 state has filed a reply stating they have approached the Supreme Court. Against the order in appeal, my lord. Order of single bench was confirmed the writ appeal.
Item 11. Yes, what happened?
Order of the single bench confirmed in writ appeal. Now in the show cause, they say they have approached the Supreme Court.
So they have filed.
They have filed that giving the diary number, SLP diary number.
Then no contempt. It transpires from the submissions advanced at the BAP that the order of this court violation of which has been erased in the present contempt application is under challenge before the Supreme Court by filing SLP which is pending.
But no order is passed.
Learned counsel appearing on behalf of the petitioner has submitted that as there is no interim order passed by the Supreme Court, there
Your
is
Lordship, the Supreme
case of
Court is,
deliberate disobedience of this court's order is made out. So, however, since the said order is under challenge before the Supreme Court, in my considered view, no case of deliberate disobedience of this court's order is made out. The contempt proceeding is dropped accordingly. Yes.
Item 12.
My lord, the order was already complied.
Complied with.
it has been complied in speaking.
Yes.
The speaking order dated 16th May, Your Lordship.
Item number 13.
The order has not been complied. And that my lord directed complaints affidavit. With regard to financial benefit, my lord, I have also drawn. I'm having a check of 31,922 my lord in favor of the petitioner. In handing over. And with regard to the revised pensioner benefit, my lord, time took time so that you know. They are awaiting for a order first since long retired person 2008, my lord. When 72 years old, they are not directed for complaints affidavit. For complaints now, they have sought become court medal. But till then, I am not concerned. I am not received single pie. Now they are giving check. They are not into anything to the right hand, my lord.
So what do you want? Check or punishment?
Yes, I want only my money. My retired person, I want money. They have not.
All right.
And my lord, the similar matter
An
is
assurance made by learned counsel representing the contemptors that the petitioner shall be paid his post-retirement benefits
my lord.
by within 2 weeks. The matter is adjourned to 4 weeks. So stop. List this matter on 4 weeks within first 10 cases. In the meanwhile, the contemptors, a compliance affidavit shall be required to be filed. Oh, stop. Yes.
I have small pair. Item C39, the same content or same order. That is not personal, therefore not same answer benefits.
39 come.
C39.
That let
How long is that request?
not now.
Because in the same order, same deal, my lord. That I am going to list my lord today. I don't see C39. Same order.
Let the matter be taken up first.
Item 14.
Someone is appearing. There is some person.
Yes,
There was
yes, there is. My lord.
dispense with.
May I please, my lord, that petitioner has been retired from service in the year 2007, but till yet his final pension has not been sanctioned.
What is the order?
My lord, direction may be,
Order,
direction was,
order.
we will send the reconstituted record.
Inspector of the Revenue to take immediate steps on recommendation made by the senior administrative officer. Bhubaneswar under Annex 2, if same has not been attended to within a period of 2 months, that is the order.
My lord, may kindly see the compliance affidavit.
Compliance affidavit, they have only say that file has been reconstructed. Pension has not been extended.
No, that was the direction that the DMET has directed us that you send the reconstituted file to us for the purpose of PA. Now, so far as our part is concerned, SCB Medical College, we have sent it. That is.
No, the order is dated 22/11/2022.
Yes, my lord.
20, yes, no.
Come to the last paragraph.
In view of the above, this is the petition stand, this would direct the operator to take immediate steps on the recommendation made by the senior administrator Odisha. The annexure, if the same has not been attended within a period of 2 months from the date of.
The senior administrative officer has, opposite party number 6 has taken some decision.
Senior
Who is
administrative,
opposite party number 6?
I am appearing for him. See, he is the administrative officer. And he has-
number 6.
So far as
The with
we are
application.
concerned,
There was some recommendation made by the senior administrative officer DMET.
yes, my lord.
There is no direction to senior administrative officer DMET. The direction is to opposite party number 6 to take immediate step on the recommendation made. Who was opposite party number 6?
He is appearing before your lordship. He is
What?
the superintendent of SCB Medical College.
So have you taken some decision?
Yes, my lord.
When?
Let me place it for your lordship. What was the annex 2? Which is sought to be implemented in that annex 2 is, it is therefore requested that expeditious step may be taken for preparation and reconstruction of service book to avoid legal complicacy and penal interest on delay. So the senior administrative officer of DMET directed him that you reconstitute the record and send it to him. He has already reconstituted and sent it to him.
That's what. What is the designation?
But now the pension has not been extended to the petitioner.
That was not the direction. This is the order which you obtained from the court. And this has to be complied with. This was complied.
That's past order, that is the pension case. Can we have a annex of you?
That is the difference.
Administrative pension case.
What is his designation? What is his designation?
He is senior superintendent.
General superintendent.
General Superintendent, SCB Medical College.
General Superintendent, Mr.
And he is
What is your name?
Dr. Avinash Rao.
Is personally present in court. First off, the case relates to disobedience of an order dated 22/11/2021, 22, passed in WPC number 28234 of 2022, whereby he was directed to take immediate steps on a recommendation made by Senior Administrative Officer DMET Orissa Bhubaneswar. First off, it is his stand that he had already acted upon the recommendation made by the Senior Officer DMET Orissa. First off, next, current counsel appearing on behalf of the petitioner states that submits that the petitioner has not been extended consequential benefits.
No. Pension only. Pension only.
Happens.
Pension has not, they retired from the 2007, but pension has not been extended till yet.
Pension,
He's a retired professor.
pension has not been paid to the petitioner. First off, there was no such direction in the order dated 22/11/2022 requiring opposite party number 6 to pay pension to the petitioner. First off, in such view of the matter, no case of deliberate disobedience of this court's order is made out. Contempt proceeding is dropped. It goes without saying that the petitioner shall be at liberty to approach appropriate forum approach appropriate forum for claiming payment of
Pension.
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 Yes.
Item number 15.
In my lords, I am permitted to submit.
Page 36 is the operative part of the order passed by the learned single judge. In order
In item number 15,
15.
order has been complied with or not?
No, order has not been complied with. But
We
the
have filed SLP. The order is at page 4 of the show cause.
Well, they have filed SLP, that is what, my lord, I am drawing your lordship's attention, my lord. The order was passed by the Supreme Court in the single judge, dated 19/4/2023. Operative part is page 36, your lordship will see.
No, but the SLP is.
No, my lord, your lordship can see, they have not challenged the single judge order before the SLP. Well, what they challenged is, the IA which was filed by them, as because they had filed the writ appeal in DA for condemnation, that was denied. So against that, they have made a specific prayer before the Honorable Apex Court to the remand the matter back for consideration.
The Supreme Court's order is very clear. The petitioner has alleged disobedience of this court's order dated the date
19/4/2023 is the order passed by the Supreme Court in the same
19/5 2023 passed in WPC number 409/03 of 2021. First off, it is stated, it has been stated in the so-called reply filed on behalf of the contemners that an SLP is pending which arises out of the said order passed by this court, wherein following order has been passed. Page 4.
Well, not against that order.
Paragraph 4 put kar doge uska. Also, in such view of the matter, I am not inclined to proceed in the present contempt matter.
My lord, may kindly mark, the SLP prepared was against the order dated 1910, not against 1905. You will also have recorded that it is against 1905.
All right, Mr. Counsel, when the Supreme Court says,
No, I am not, my lord, you will also,
when the Supreme Court says,
my lord, it should be brought to your
it
lordship.
should be brought to the notice.
Yes, my lord, my lord, I don't stand.
That sentence has some meaning.
My lord, I don't stand on your lordship's way, my lord, your lordship. Only thing I want to bring it to your lordship's notice that the order which is challenged.
So once that is disposed of.
19, yes, my lord. Your lordship grant liberty so that we can raise with your lordships.
That liberty cannot be granted because the matter is there. Such liberty. Once that is decided, you are free to approach. Who can stop you?
Okay.
Item number 16.
There is a direction to consider the impediments and take it as action has been taken on 9/5/2024. And
Yes,
this
madam.
has been disposed of by the Home Department.
Yes, complied with
I will challenge it. I will challenge it.
liberty.
Item 17.
Well, here the order has not been complied with, as has been directed by the Supreme Court. They themselves admit they have filed a so-called yesterday serving me a copy, where they have said that they have partly, after receiving part information, they have proceeded further. And they have further asked for 2 months' time for compliance of the order fully. You will may kindly come to para 9 straight away at running page 5 of the so-called reply filed today.
Let me see the order first.
Well, order was passed on 17/5/2023. And after the first round of contempt was over, granting them further time, since they didn't comply, the present contempt petition has been filed, where they were directed to comply with the order. And they themselves have admitted that they have received only part information, which will also.
No, your representation was to be disposed of. Whether representation has been disposed of.
My lord, kindly see the order, my lord, 3/7/2024, page 7, my lord. The speaking order was passed, my lord, and the amount was quantified to be 14 lakhs, and he was deputed to the Panchayat Raj Department, Housing Urban Development but department for a period, my lord, and accordingly some 8,28,28,28,405 has been paid to him, my lord.
Out of
And the balance sum of them required by the Housing and Urban Development Department, my lord. And Housing and Urban Development is not a party, and he was in the deputation to the Housing and Urban Development Department, my lord. And we have also pursuing the Housing and Urban Development to pay the balance amount.
We'll list this matter on 4 weeks. So as to enable the contemners to ensure that the sports order dated 17/5/2023 passed in WPC number 15554 of 2023 is fully complied with. So stop. If the order is not fully complied with in letters and spirit, the courts have considered initiation of contempt proceeding against the opposite parties in contemners. 4 weeks. Do it.
Item number 18.
In this case, the lordship direct to dispose with dependence. We have considered and rejected it.
Presentation complied with. The representation has been disposed of. Liberty minor. Yes.
And personal appearance of the Secretary Health Department.
Personal secretary appearance. So and so. What's your name?
Having Pandit
Dispense with.
Public.
Old matter item number 19.
Non appears. Dismissed.
Item 20.
Yes. Same order.
Item number 21.
Same order.
Item 22.
Same order.
Item number 23.
Same order.
Item number 24.
Same order.
25.
Same order.
Item 26.
Same order.
27. Item number 28.
That's item number 28 already complied.
Complied.
Okay. Item 29. Item number 30.
Item number 30 on behalf of Mr. SS, thus the order has been already complied with.
Item number 31.
Compliance affidavit has been filed on behalf of the contemners. We are 31. No, there is no representation on behalf of the petitioner. Contempt proceeding is dropped. Yes, sir.
32. May I please your lordship? The original order is in the page 8 annexure 2. That in that view of the matter, the writ petition is disposed of by giving liberty to the petition to file a certified copy of this order and copy of the brief before the opposite party number 1 within 7 days. On such event, her representation in annexure 6 shall be considered and disposed of after affording reasonable opportunity.
So whether the representation has been disposed of?
My lord, it has not been disposed of. They have. It has.
I don't know because somebody's name appears at Mr. Ramakant Koro was appearing for the contemners.
Which item is this?
32.
32.
30.
Like 2 weeks time is allowed for the state to file so-called reply as to whether this court's order violation of which has been alleged in the present contempt application.
It's housing board, we can that here.
Housing board.
It's housing board. That's why
Housing board.
Mr. was appearing for the containers. Mr. Koro was appearing for the containers. Unfortunately, he is no more lost. So my friend may take press notice because the housing board, we cannot appear for the housing board.
All right, issue notice. 1 week.
Item number 33.
Yes. 33, no one appears.
Item 34.
Item 34, may I please lordship, I am the petitioner. 2 times representation did not consider, information not considered.
Yes.
The dispensation has been considered and the order has been passed. I can give a copy to.
Give him a copy. Complied with.
35, compliant my lord.
Complied with.
36,
My lord, appearing on behalf of Mr. P.K. Misra, we have not received the SOCOS filed by the office.
It has been complied with.
Yes, I filed the Sokaz affidavit. My friend wants not Sokaz affidavit, I can give you not.
Give him a copy. It has been complied with.
Yes, what we have affected is the office can be looked at. Not so, in paragraph 13 of Sokaz, we have already complied the order of dismissal, so contempt may be dropped.
All right. Complied with.
37,
No, no.
item 38,
38 complied my lord.
Complied with.
Okay.
39,
Non appears.
item number 40,
No instruction.
No instruction.
item 41,
Non appears.
item number 42,
No one appears.
item number 43,
No one appears.
Storage is there, compliance was to be 42,
Compliance has been filed.
42.
The Sokaz affidavit is already been filed. My lord. It has been filed.
Compliance affidavit has been filed. There is no representation on behalf of the petitioner. The contempt proceeding stands stop.
43 also.
46.
So was filed by the OPA.
43 same order.
Item 44,
Infructuous. Infructuous.
44, 48. Item 46,
Yes. None appears.
item 47,
47 ordered 10/1/2018, which was extended, notified by ordered 12/2/2018. As per my instruction, not complied with.
Complied with.
Not complied with. As per my instruction, there.
Yes. Yes, sir. What was the order? 47.
47.
What was the order?
Order I have quoted at 10/1, ordered at 10/1/2018, at +9 of my petition, my lord. Order was to dispose of the fresh representation after giving the opportunity of hearing.
Yes.
I'll find out.
Every time the court is making this observation, that you have to dispose of all the representation and tell the court that these are the cases in which the representations have been disposed of. 2 weeks' time is allowed for the state, for the contemners.
This same case notes, where the lawsuit said one case lawsuit reserved the judgment. Bomb drivers working under the not Gram Panchayat. So I think the batch of contents of.
No, you have to just dispose of the representation.
So far as others we have paid, this will have taken certain whether amount will be paid or not. 19 will also
Allowed to learn AGA to seek instructions as regards compliance of this court's order. Yes.
48,
Infructuous.
49,
My lord, the order dated 19th of September 2029 may kindly be seen. Last part, my lord, Mr. B. Shatrapati, Learning Council, Standing Council of School
Order
and Master
dated?
Education Department,
Order dated which order?
19/9/2019.
19/9/2019.
Yes, my lord.
Where is that?
My lord, last part, one paragraph. Mr. B. Shatrapati, Learning Standing Council for the School and
You
Master
have
Education.
quoted that order.
My lord,
You have quoted.
yes, my lord. That has not been complied till to date.
27/6/2019, I filed a compliance affidavit.
Today, 27?
6/2019.
Thereafter, the order is passed on 19/9/2019.
That is not there. So last year only calling.
Where is that order? 19/9/2019 order is where?
My lord, can I?
You have not annexed.
No, my lord, that is the, in this, during the pendency of the contempt petition, your lordship passed order.
Second contempt.
Order number 3 dated 19/9/2019.
Just a minute.
I have taken a copy of it, my lord, sir.
This order was passed in contempt proceeding.
Yes, my lord.
Let us see the main order.
Main order, my lord.
You has been
Yes,
violated.
yes, my lord. The main order is, my lord, at running page. That is on 22nd of February 2017. That is WPC number 15520 of 2016. Considering the submission and views, reviewing the limited grievances, the writ application is stays disposed of, directing the opposite parties to implement the order of the London State Education Tribunal passed on 1/3/2011.
Whether this has been implemented or not,
Yes, sir. Paid in amount. Now we dispute that amount which has been received.
that cannot be gone into.
No, my lord, that is not, your losses passed an order that.
Forget that. Contempt proceeding, we have our limitations. The petitioner in the present contempt application has alleged deliberate disobedience of this court's order dated 22/2017 passed in WPC number 15520 of 2016. Operative portion of the said order reads thus. First off, a compliance affidavit has been filed on behalf of the contemners, stating therein that the order passed by the State Education Tribunal in GIA case number 73 of 2009 has been complied with. First off, when senior counsel appearing on behalf of the petitioner has, however, submitted that there is no full compliance of the order of the tribunal, in as much as he has been paid amount less than what he was entitled to. First off, in the where is the order of the tribunal?
Now, as the order of the tribunal is, that has not been. That has not been annexed.
The order of the tribunal has not been annexed. First off, it cannot be deciphered from the pleadings on record as to which part of the order of the tribunal has not been implemented. First off, learned senior counsel appearing on behalf of the petitioner has, however, drawn this court's attention to an order dated 19/9/2019 to contain that this court should ensure that the petitioner is paid the amount which he is legally entitled to. First off, the said submission is not acceptable to this court. First off, in a proceeding, in a contempt proceeding, the court's jurisdiction is confined to violation or otherwise of the order passed by this court. First off, in a contempt proceeding, the court is not required to go beyond the scope of the order passed. Full stop. In such view of the matter, I am not inclined to proceed any further in the present proceeding. Full stop. This contempt proceeding, contempt case is accordingly dropped. Full stop. It is, however, observed that the petitioner shall be at liberty to raise his grievance before appropriate forum in accordance with law, if according to him, the amount which he is legally entitled to has not been paid, despite order of the, despite any who has not been paid by the concerned authorities. Yes. Next.
Item number 50.
My lord, I am to approve the concerned authority, last part of the order, my lords have said. If any views are that, then he is to approve the, or whatever.
This is what.
My lords have observed that.
Yes, yes.
Yes.
Item 50.
Yes, you want to hear.
51.
No instructions. No instructions.
52.
52 complied with mirror.
Complied with.
53.
Next, my lords, page 7, my lords. Directed to opposing party to submit the representation. Then, my lords, they have not complied with order, my lords, I find a contempt application. And contempt application, another 3 months time was granted. Then, my lords, they also not complied the order, my lords. And this is the second contempt application.
Yes.
My lord, we have filed the so cause affidavit dated 4/10/2019. 2019.
Order complied with.
Yes, my lord. And
Copy was not sought to.
I'll serve a copy.
Serve a copy order is in complied with. Representation disposal.
What they have complied with, my lords, that is.
That
Give
is
him a
the-
copy.
Yes, I'm giving a copy.
Give him right now.
This is 53, no?
Yes.
762 of 2018.
Speaking order is there. I'm giving the order. copy.
Give him. It is stated by an AGA appearing on behalf of the contemners that the representation
Has been disposed
which
of.
was directed to be disposed of by this court's order, violation of which has been alleged in the present contempt application, has been disposed of.
Right, order
Copy
dated
of the disposed of by an order dated
20th April 2018.
24, 2018. Suppleant counsel for the prisoner submits that he does not have in his possession a copy of the said order. Must populate a copy of the said order dated 20th of April 2018.
Yes.
Pardon, my lord, the notice was issued on my lords on 7/1/2019 in the second contempt application.
No, that is on the
See,
first date.
if we move so fast in such matters, then this is what will happen. Your application was disposed of with a direction to dispose of representation
In 2017.
17.
And
Soon thereafter, you file a contempt application with an allegation that contempt it has not been complied with, and that was also disposed of
in 2007.
without ascertaining whether the order has been complied with or not. The order in 2019 was passed. So this is what happens. So unless we have the view of the other side in a list, then it is bound to happen. So, be handed over to learned counsel for the petitioner in course of the day. So stop. It goes without saying that the petitioner shall be at liberty to question the correctness of the order before appropriate forum in accordance with law, if so advised. Yes.
Item 54.
54, my lord. Order of honorable board dated 21/11/2017, not complied with, my lord, till today. The judgment passed in the year 2017, my lord, that is 21/11/2017.
Yes.
Thereafter, they have not complied with. The petitioner filed the present contempt application.
Let me see the order.
My lord,
Let me see the order.
or you will also kindly see page 19 of the judgment. Para 17. In terms of the above discussion,
Just a minute. Paragraph 17.
paragraph 17.
Yes, the so is that there is an appeal before the Honorable Supreme Court and stay order has been granted. I have to take the instruction regarding status of that.
No, for that reason, I also submit that. The appeal is dismissed, my lord. Dismissed, SLP dismissed on 16/4/2024. Modifying that order, that the Honorable Supreme Court directed, we have used the issues order.
Once the order has been modified,
That the extent to benefit from first in December 2003, not 99.
so there is no contempt made out, Mr. Counsel.
After this order, they have not
After
applied.
this order, after the order was passed in April,
Yes.
now you are in July. So where is the question of disobedience?
No, you will accept directly implement the order.
That they will do. That they will do, and since the order has been modified, this court's order must be the order of the Supreme Court.
This honorable court directed quash the order dated High Court 2000.
Sir, please try to appreciate this. There was an order passed by this court. Against that order, the other side went to the Supreme Court. The Supreme Court, according to you, has
No, modified.
Dismiss, you have stated that the special for the petition for special leave to appeal the dismissed accordingly, except for clarifying that the respondent shall be entitled to salary to be computed on expiry of the 3 months recorded from 29 August 2003. In other words, the petitioner state shall pay the arrear of the salary to the private respondents from 1st December 2003 onwards. Therefore, only
how they will comply with the order. The petitioner has alleged disobedience of an order of this court dated 21/11/2027, passed in WPC number 13158 of 2013. So it appears that the matter and that the order was challenged by the opposite parties in the writ proceeding, and it went up to the Supreme Court. The special leave petition filed before the Supreme Court, it has been dismissed recently by an order dated 16/4/2024 with the following observation. With the following observation. Paragraph has been dismissed. Of the dismissed, the order reads as under top. Since this court's order has been clarified later by the Supreme Court by an order dated so and so, I am not inclined to proceed in the present matter, case, contempt case. So stop the contempt proceeding. No deliberate disobedience of this court's order can be said to be made out, as the contemners were pursuing their case before the Supreme Court by filing SLP, which has recently been dismissed on 16/4/2024. So stop. Next, it goes without saying that once the SLP has been dismissed and dismissed with certain clarification, the contemners are duty bound to act accordingly.
Yes, ma'am. From 2023 to onwards.
You all act accordingly in terms of this court's order and subsequent order passed by the Supreme Court. Read with the subsequent order passed by the Supreme Court. Yes.
Item 55. 55 and 65 also same judgment. Batch of cases are filed, madam. They have in all batch of cases, they have gone to Supreme Court to pass this order, madam.
55, 65.
55 and 65. Right.
Item 56,
No instruction.
No instructions.
57,
No one appears.
58,
None appears.
59. Order already complied, madam.
Complied with.
Item 60,
None appears.
item 61,
None appears.
62,
My lord, the petition doesn't close this application.
Dismissed as not pressed.
My lords, I pardon, item 58 not pressed.
58. They are not pressed. No one appears. Then
item 63,
none appears.
64,
Item 64, Your Worship, the petitioner does not want to press this application to pursue his remedy before the appropriate authority.
Doesn't want to press.
No.
66,
None appears.
67,
None appears.
68,
None appears.
item number 69. Wait, please, your lordship. I am appearing for the petitioner.
I have nothing.
Petitioner, may I finish?
Also, be kindly give one good time so that I can file to my showers indicating the present position of the case.
No, whether the order has been complied with or not.
It has not been.
Application, this honorable court remanded the matter arising out of the regulation to 1951. My lord, while remanding the matter, this honorable court has granted order of status quo. They are alleging that I have violated the order of status quo. That's why, my lord, your lordship may kindly give me some time, my lord.
Yes.
Lordship, as your lordship pleases, but I can make out a case today itself.
No, you can make out a case, but she is trying to develop a defense.
Okay, lordship, I have no.
As requested on behalf of the contemners, list this matter on 4 weeks. So as to enable her to file additional so-calls reply.
Lordship may permit me to file an additional affidavit.
Why?
I have some document.
We have to see the order. Whether that order has been complied with or
Complied.
not. That's all.
Publish. Item number 70.
Appears.
Item 71. Already complied, now.
Complied with.
72 also. 72 also non-compliant. 73.
No, appears.
Item 74.
No, appears.
75.
Some order.
76.
Some order.
Item 77.
My lord. This case arises out of the WC case. This present case arises out of the WC case.
This arises out of what?
WC, Workmen Compensation Act, 1923. Here, the company is claimant. And their son died during the course of employment. And accordingly, all the petitioner filed claims from before the labor court. Labor court after annexure 1, annexure
File this contempt application.
contempt application, because order of this of the court.
Please let us see where is the order.
Yes, your lordship, kindly see, page 28, annexure 4.
Annexure 4.
Annexure 4.
Just a minute. Just a minute, please. It's item 77. Just a minute.
Contempt.
The award confirmed by the High Court and that is to be executed. Or the content.
Contempt court, executive court not dissolved the order of this honorable court, annex of court. Specific direction given.
Just a minute.
My lord.
Yes, so what is the direction?
Direction at last para, page 38, para 15. In view of the above, the writ application is allowed and the improved order is passed. Appealed card number 2, Commissioner for Workmen Compensation cum Assistant Labour Commission Qatar is directed to take steps for recovery of compensation amount awarded in term of judgment 30.
Yes, what is your stand?
So cause has been filed. Firstly, this is a award which is to be executed before the original court. But still I have filed a so cause, you lordship may see, so cause filed by the Joint Labour Commission dated 30th September 2022.
Yes.
You confess first affidavit. That you break apology or honorable court that you have.
What is his stand?
मतलब they admit their fault. Affidavit, counter affidavit, so 30.
I will discuss with the country. Something is that I will ensure that it will be.
2 weeks I requested on behalf of the contender.
2 weeks time.
As listed matter on 2 weeks as requested on behalf.
What kind of day? Any date you also kind of 2 days.
2 weeks means 2 weeks. But today is Friday, not next Friday.
Mine, problem. 3 cases are same.
78 and 79.
77, 78, 79. But
Not to item number 82.
Order dated 11/4/2016 is not complied.
where is the order?
Annexure 1, lordship, last verse, page number 9.
The representation has not been disposed of.
Lordship.
Who was required to dispose of?
Collector, lordship, Kendrapada.
Collector Kendrapada. Yes.
Ransom type should have been take instruction actually.
But why could you not receive instructions so far? This is.
He was not even so much.
Huh?
He has not received the notice mail.
Oh.
Collector mail.
Collector has not received the notice, but he has
not returned mail. Perhaps he has not received.
Notice was issued. You don't represent him.
Depending in my done some time so that.
1 week. This is matter on 1 week. First to enable an AGA to seek instruction from the contemners as to whether this court's order has been complied with or not.
Item number 83.
Mr. These cases were listed on last Friday also.
Right.
And why they are not, you are not aware of the fact whether the representation has been disposed of? If it doesn't happen next Friday, I am just warning that I'll direct Chief Secretary to personally present. His state of complete. This 2018 matters, you don't know whether the representation has been disposed of. Do you have any idea whether representation has been disposed of?
No, representation has not been disposed of.
So do you have definite knowledge that the representation has not been disposed of?
No, lordship.
Have you been instructed by your client?
No instruction, but that is representation is pending, lordship.
The instruction you have received?
Yes, lordship.
That the representation has not been
pending.
disposed of?
Yes.
All right.
Item 83.
On appeals.
84.
84, may I please your lordship? I am in fifth, my lord. Order dated, my lord, 13 to 2017 has not been complied with, my lord. Page 8 of the contempt petition, my lord.
Yes, what is the order?
Order, my lord, fourth para. Considering the limited grievance of the petitioner, this court dispose of the writ application with an observation that if the petitioner filed a representation before the Commissioner cum Secretary, Department of Housing and Urban Development, Bhubaneswar, opposite Patna number 1, within a period.
Yes. Any instruction?
No, I don't have. I'll take it.
Same order.
Okay, sir.
Item number 85.
On appeals.
86.
It's order dated 13/10/2017 in page 7.
Tausillar, Bali sir. Order the 13/10/2000, page 7.
Yes, what is the order?
This one called directed to the Tausillar Sadar Bali sir to take a decision on the, as per the notification of 2013 for recording of the line in name of the petitioner. And the petitioner has submitted the order sheet on 26/10/2017 in page 8.
Order.
Order page 7.
Disposal of application file for settlement.
Khasiyallah.
No instruction.
No, I don't have instruction. Let him serve a copy, or even I don't have copy. So that I'll take instruction.
Serve a copy.
Yes.
1 week.
87.
87 is not present.
No appeals.
Not a present, I was there in VC.
Yes. 87.
Not present. Not present.
Not pressed.
88.
Lordship, so copy not so.
So cause. What is there in the so cause? Whether the order has been complied with or not? So your representation has been disposed of. Your representation has been disposed of, madam. And that was the direction. The petitioner has alleged.
Let him serve a copy, my dear. That's my idea.
As requested on behalf of the AGA, list this matter on 1 week.
89.
On appeals.
Item 90.
Some order.
Item 91.
My lord, item 90 complied, my lord.
Complied with.
90 complied. 91.
90 and
91. No.
non appeals.
Item 92.
Some order.
93.
93 already complied, my lord.
Complied with.
Item 94. The order not complied with, you will also be getting at page 12. Relevant part. Needless to say that the company in liquidation shall discharge its liabilities by paying the dues of the financial institution.
Page the order.
My lord, page 12, my lord. Operative part I am ready. This is the order passed by the unknown company judge in the Cooperative. Last paragraph, my lord, needless to say. The company in liquidation shall discharge its liability by paying the dues of the financial institution secured.
So whether contempt petition will lie against the order passed by the relevant company judge.
It will be, my lord, it's a,
So you could, the matter is over. How?
No, it is pending. Case is pending.
So you could have filed the application before the land company judge.
It was filed, my lord. Since thereafter, the university passed another order in 2019.
Maybe, but this is this is not the forum for you.
I will
This is
check
not-
it up, my lord.
You could have.
I will check it up the position of law.
Mr. Counsel, whatever petition you had to file, you could have filed before the land company judge.
Yes.
No court can entertain such application. There is the question of
279,
yes.
279.
Yes. The petitioner has alleged in the present contempt application disobedience of an order passed by the land company judge in company petition COPET number 32 of 2003. So, in the court's opinion, the company is in liquidation and the company petition is still pending. So, in such view of the matter, this application is disposed of with a liberty to the petitioner to approach the company judge raising the grievance as has been raised in the present contempt application.
Yeah, I'm appealing for opinion 2 and 3. My appeal will not be that.
Appeal. Yes.
Item number 95.
Non appeal.
96.
Yes. Non appeal.
Item 97.
Non appeal.
Item number 98. 99. Item 100. Item 101. 102. Item 103.
My lord, the order starts from the page 11 of this court. At page 11, the operating portion is at page 52. It is evident from the pleadings made in the writ petition that no decision has been taken by the authority in the light of the judgment rendered by the Honorable Appeals Court in the case of Mamata Mount Supra, in the case of the petition, this case. As such, without entering into the merit of the claim of the petitioner, it would be appropriate to direct the Director of Higher Education to take a decision on the claim of the petitioner within 3 months from the date of production of the certified copy of the order. Thereafter, my lord, it has not taken, so Contempt 680 of 2018 was filed. Annex 3, the order was, my lord, at page 57. Let the authorities comply the order. If not complied within the period of 3 months thereafter. Till to date, my lord, not complied.
Yes.
Grant some time.
2 weeks.
My lords have already issued notice on 28th of August 2018. They have not given any show cause or any reply till to date.
No, but why don't you have any instruction?
Within 2 weeks, madam. We are written letter to
See,
them.
but please understand, the government should understand that this court is struggling with such applications. 10,000 contempt applications pending in the High Court for this, for you to consider. And you don't have any idea this contempt application was filed in 2018. What's going on? As requested on behalf of the contender, list this matter on 2 weeks. So stop. It is made clear that if on that date, the court is not informed about the full compliance of this court's order dated 11/12/2017 passed in WPC number 590 of 2003, the court will take serious view of the matter and serious view of the matter by initiating contempt proceeding against the contemners.
Item 104.
Millers, I may be pardoned, Millers. 100 and 101, I may be permitted to withdraw, Millers.
100, 101 permitted to withdraw.
Item 104. None.
Non appeal.
Item 105.
My lord, order dated 2010-2014 not been complied, my lord. Order in the phase 3, my lord. The operative portion is on phase 4, my lord.
Are you sure that the order has not been complied with?
Yes, my lord, yes, my lord. As per my instruction, there is no order not been complied.
What was the order?
My order in the order operating portion of the phase 4, my lord. Considering the limited grievance of the petitioner, this application is disposed of with a direction to the executive engineer Kalahandi R&D division, Bhavani Patna district Kalahandi, opposite pad number 3, to consider the representation of the petitioner in the light of the decision of this court, referred to the above in the paragraph 2 of the order, my lord, WBC number 29,271/2011, Mahesh Prasad Mishra versus State of Orissa. That is in the light of the decision passed in the Mahesh Prasad Mishra versus State of Orissa, referred to the dispose of same within a period of 2 months. Thereafter, we file another contempt petition. This honorable court in the page paragraph 4, my lord, page 6. This honorable court granted another 2 months to comply that order. Till then, that has not been complied, and in the year 2019, notice has been issued by this honorable court.
Why these are 2018 matters? Shocking.
This petition, my lord, he has not submitted any document, my lord, that he has served the copy, my lord.
What copy?
The copy of the order of the order of this honorable court, my lord. He has not served, my lord.
Take this plea. Take this plea in your counter when you file your so-called reply. Take this plea that you could not comply with the order because a copy of the contempt petition was not served upon you. And I assure you that I'll punish the contender on this ground itself. What is this? How can you take this plea that you did not have a copy of the contempt application? You did have a copy of the order. You were required to comply with that order. How can you take this plea? There is an order passed by this court. They are not required to approach you for compliance of the court's order. Please don't take this plea.
106.
2 weeks.
Item 106.
But the opposite party.
Yes.
Hearing his statements 91 proceeding for demolition of unauthorized construction.
What is the order?
Order means status quo is there. Status quo order is not complied with. Complied with by the opposite party number 5 means the private property party.
Where is the order? Let me see.
It is
15/5/2018.
I was 15/5/2018. But the opposite party minors.
The writ petition is pending.
Writ petition is pending. Minors has come with minor.
All right, I'll take up writ petition.
Minors.
Let this matter be listed. Along with, let this contempt application be listed. Along with WPC number 7803 of 2018 on 4 weeks before the assigned bench.
Item 107.
7, my lords, I am appearing for contempt number 4. The order has been complied with, my lord. He has been regularized.
It is stated by
Order, my lord. Item number 104, my lord, already comply, my lord.
104 complied with. Discuss 107, it is stated no one appears on behalf of the petitioner. It is stated by on behalf of opposite party number 4 that this court's order has been complied with. The contempt proceeding stands stopped accordingly. Yes.
Progress. Item 108.
Yes.
In this case, I am for the petition of contempt matter.
Comparative.
Yes, National was not filed by the main case is pending. I am appealing for the opposite party. Main case is pending, my lord. I against the interim order. I am for the petition before the honorable single judge in the writ petition.
All right.
In their case, we have already filed counter in that case, man. Who is the analyst to discuss with his case? That we have already filed counter. Their case is pending. We have already filed counter. They have not filed so much in my contempt petition.
Let this matter be listed along with WPC number 11406 of 2018 before the assigned bench. Yes.
Item 109.
Yes.
110.
Should not pressed.
Not pressed.
111.
No instruction. No instruction.
No instruction.
112.
Petitioner may want to press the application.
113.
Annexure 1, since there's 17 to 9, my lord, the authority person of the order, my lord, and it last page 9, my lord.
Page?
Page 9.
Yes.
However, considering the third paragraph, my lord. However, considering the willingness of the petitioner to deposit 50% of the outstanding as on date, it will be open to the petitioner to approach the private petition financier, opposite party 2, along with the deposit of 50% of the outstanding dues as on date. Within the period of 3 weeks, in such event, the private financier, opposite party 2, shall do well in taking a lenient view in the matter of not taking any corrective action against the vehicle during registration of sponsor, and refresh the rest of outstanding dues with outstanding installment money. Then, my lord, in annexure 2, I sought for some amendment. Instead of outstanding due, the EMI due, my lord, has been shut.
Still, this writ petition was not maintainable against a private financer.
And my lord, this is the contempt.
This contempt.
But the writ petition
What is this?
has been directed, my lord.
What is this? The petitioner has raised disobedience of an order dated 12/7/2018, passed in WPC number 11805 of 2018. Stop. It is apparent from the order sheet that the writ petition was disposed of on the same day with certain direction to the opposite party number 2 to the writ petition, who was a private financier. Stop. The opposite party number 2 was not noticed before passing of the order dated 12/7/2018. Stop. In such view of the matter, no case of deliberate disobedience of this court's order is made out. The contempt proceeding is dropped.
No, pardon, my lord. This one, my lord, the RTO, counsel of the party, my lord. RTO, restoring, RTO was the party, my lord, with the state government.
Is there any direction to RTO?
No, not directed, my lord.
So the direction is to a private person
My lord,
who was not noticed,
my lord.
and you want the court to initiate contempt proceeding against him.
Are the single judge directed, my lord?
Yes, sorry.
My lord, let's my liberty so that is available.
The petitioners shall have liberty to approach the appropriate forum in accordance with law for the redressal of his grievances.
All the connected.
All the similar matters, my lord.
Yes.
Item 114. 115.
Complied, your lordship. Show cause. Complied.
116,
16, 17 is also minutes complied.
item 118,
Non-appears. So moved.
118, your lordship. The SLP was admitted and the appeal has been restored, your lordship. In 118, your lordship.
Yes. What do you think? Complied with?
Yes, your lordship. It's also listed on the 1st of July, your lordship.
The court has been informed. that the a suo motu contempt proceeding has been initiated. Within suo motu contempt proceeding has been initiated for deliberate disobedience of this court's order passed in CONTC number 690 of 2018.
Yes, sir.
So it appears that the sunset contempt case had arisen out of WP number Hmm? 4394 of 2016 disposed of on 4/1/2018. So against the said order dated 4/1/2018, a writ appeal was filed against this order.
Yes, your lordship. A writ appeal was filed.
Writ
The writ appeal was dismissed on grounds of delay.
raised to WA number 280 of 2018, which was dismissed on the point of limitation. First off, the said order passed in the writ appeal has been set aside by the Supreme Court by an order dated 12/1/2024, passed in Civil Appeal number 431 of 2024. So accordingly, the writ appeal has been restored. So in such view of the matter, the present contempt proceeding stands strong. Yes.
Item 119.
May I please, Your Lordship. Lord, this honorable court had, through order dated 30th August 2017, had directed the opposite parties to take up the case of the petitioner and complete the removal of
Where is that
encroachment.
order?
My Lord, I have not annexed it, but I have quoted the operative portion in the contempt application.
Where is that?
Page number 3.
Yes.
My Lord, after that, they did not take any actions, so we filed another contempt. And this honorable court directed them to dispose it off within 6 weeks.
Yes.
But we have already complied that order. We have heard that the parties, the enforcement officer, and disposed of the copy to them. That is the copy letter number 9499.
That has been disposed of, Mr. Counsel.
My Lord, if I may, please your lordships. My Lord, the opposite party number 5 in the writ petition, who has encroached upon the public road, we are not able to move out of our house because of that. They have been filing different cases in different forums.
That they can do.
My Lord, a writ petition is also pending. Lordship may dispose it off on that.
The petitioner has alleged disobedience of this court's order dated 30/8/2017, passed in WPC number
17973 of 2017.
17973 of 2017. So it has been stated on behalf of, it has been submitted on behalf of the contemners that the said order of this court has been complied with, and
Copy has been communicated to him.
and an order has been passed on the petitioner's representation.
Order number 9499, dated number 6/4/2018.
An order has been passed on the petitioner's representation. So next learned counsel appearing on behalf of the petitioner has submitted that the private contemners, that who is doing that?
My Lord, opposite party number 5 of the writ petition.
That opposite party number 15 is not in the contempt proceeding.
No, my Lord, they are not.
Next, in such view of the matter, the present contempt proceeding is dropped. Stop it goes without saying that the petition shall be at liberty to approach appropriate forum in accordance with law. If law for raising his grievance, if any, in relation to the dispute in question. Yes.
Item number 120.
Non-comprehensive order dated 28/7/2017 to consider the request until yet not considered. The carry regulation of the petition.
Your Lordship, in this matter, they have sought for the finance department's approval for a junior clerk post, regular post. In the meantime, they have given them a consolidated pay of 8,880, Your Lordship, from
So what is
6,000.
the direction?
Page 11. Page 11. Therefore, this court is of the consider that the petition is continuous service, let the concerned authority take a decision, provide the petition is concerned for regulation of service of petition in accordance with law, keeping new law laid down by the appeals court in Secretary State of Karnataka and others, versus Humanity and others, within a period of 4 months from the date of communication. Page 11, my lord.
So they say that they are in.
Not delayed, not considered.
Your Lordship, they have written to the Joint Secretary to the Housing, to the Finance Department for a creation of a junior clerk post, Your
Frankly
Lordship.
speaking, even I have not been able to fully understand what law has been laid down in case of Uma Devi. All right, and there is a direction by this court to decide in case of Uma Devi. It's very difficult. Very difficult. If law keeping in view the law laid down is and so they have to take a decision. They will be taking decision. Have to
So,
take a
Lordship,
decision.
in the meantime, since there are no regular posts they've asked for a concurrence of a junior clerk post, Your Lordship. In the meantime, rates is consolidated paid from 6,000 to 8,880.
The portion of the order passed by this court dated so and so in WPC so and so, violation of which has been alleged in the present contempt application. So, next one, AGA has submitted that the steps have been taken to. The direction was to whom? The direction was issued to whom? Concerned authority. That the concerned authority take position.
Secretary Housing and Urban Department, Your Lordship.
And steps are being taken for creation of post for regularizing the service of the petitioner. So, in such view of the matter, in the court's opinion, no case of willful disobedience of this court's order is thereof. Contempt proceeding is dropped.
Item 121.
121, no instruction. No instruction.
No instruction.
122.
22 also same, my lord.
Same.
123.
Complete.
124.
There are 125 to 130 no instruction, my lord.
124.
125 to
130.
125 to 130.
yes.
131.
Yes.
132.
Permitted to withdraw.
133.
1. Yes.
Direction given to the collector Jagasingpur. Copy number 4.
Where is the order?
Order written 19/3/2018.
Where is the order passed by this court?
Page 8. Page 8. Opposite party number 4 to the.
Disposal of representation.
Yes, Your Lordship, it has been complied with. We have a letter from the collector.
It has been
And the same
complied.
has been also intimated to the High Court also, Your Lordship.
Yes.
Let's have the copy, compliance copy.
Do you have a copy?
No, Your Lordship, I'll serve it.
The petitioner has alleged disobedience of 133. The petitioner has alleged disobedience of an order dated 19/3/2018, passed in WPC number 88 of 2018, and another order dated 26/7/2018, passed in CONTC number. What is that? What is the CONTC? One 1005 of 2018. Stop. By said order dated 19/3/2018, the collector was directed to consider to dispose of a representation filed by the petitioner. Also, learned counsel appearing, learned AGA representing the contender has submitted that the representation has been disposed of. Also, in such view of the matter, the contempt proceeding is dropped. It goes without saying that the petitioner shall be at liberty to question the correctness of the order passed by the collector before appropriate forum in accordance with law. Yes.
On 34.
Lordship, non-compliance of order dated 31/7/2018. The Supreme Court directed to dispose of the consider the petition, but your Lordship, the land collector had only mentioned that
Work has been disposed of.
No, my lord.
See, Lordship, it has been complied with. The plot has been demarcated, your Lordship.
My lord.
And they have been also issued with a work order to build a house in the right plot, your Lordship.
No, my lord.
All right, let me see the order passed by this court.
My lord. Page 8. Page 8 of the contempt.
Read the order which is passed.
My lord. The petitioner is stated to have filed a representation by NSRC before the collector Bolangir opposite party number 2 for the alleged arbitrary action of the state authority in issuing work order for construction of Pradhan Mantri Awas Rural.
The representation was directed to be disposed of. Nothing else.
My lord.
So whether the representation has been disposed of or not.
They admitted that on my plot,
nothing except for disposal of the representation.
My lord, they have not passed any order.
They have not passed any order.
My lord.
Lordship. Inquiry has taken shape also pursuant to the representation.
They have served to me. They admit in their
All right. See, there is, listen to the order. The petitioner has alleged disobedience of an order dated 31/7/2018 passed in WPC number 10809 of 2018, whereby the collector Bolangir was, whereby while disposing of the writ petition, the collector Bolangir was directed to dispose of the representation filed by the petitioner. Stop. It is stated by learned counsel, learned AGA representing the contemners that the petitioner's representation has been considered and action has been taken. Stop. Learned counsel appearing on behalf of the petitioner, however, disputes the position. Stop. Next, upon perusal of the materials on record, I find that the writ petition was filed on
Filed on 25/6/2018.
25/6?
2018.
This is 125.
134.
The writ petition was filed on 25/6/2018 and petition was filed on 1/5/2018.
That the petitioner had filed the representation on 1/5/2018 and When did you file your writ petition?
My lord, 25/6/2018.
And soon thereafter, he filed the writ petition on 25/6/2018, which came to be disposed of on 31/7/2018, on the very first day. Full stop. Next. In such view of the matter, in the court's opinion, no deliberate disobedience of this court's order is met out. The contempt proceeding is dropped.
135.
135 will also, I am appearing for the opposite party.
So whether the order has been complied with?
Already complied.
Complied with?
Yes.
Complied with.
Obliged.
136.
My lord, I mean, VC, your lordship.
Yes.
The order has been complied with, my lord.
Complied with.
136 to 144.
Yes, 136, 144.
Yes, obliged.
Yes.
145.
Yeah, please, Your Lordship. Lordship, the order has not been complied with.
144.
136 to 144.
144 or 136 and 142 बोले ना? Yes.
Yeah, please, Your Lordship.
145.
The order has not been complied with.
What was the order?
My lord, at page 13, my lord, interim it was directed that there shall be interim stay operation of the order.
Where is the order? Where is the order?
At page 13, my lord.
Page 13. This is 1850.
1870, my lord. 1870, 2018.
Just a minute. Page
13. 1313.
Yes.
Lordship, as an interim measure, it is directed that there shall be interim stay of operation of the order under Annexure 3, by which the petitioner was suspended without any show cause, provided the petitioner has physical ability to do the seva in questions of the deity. The order of stay shall be effective till the next date. My lord, in that writ petition, either they are filing the counter affidavit.
The writ petition is still pending.
Yes, my lord.
Still.
Very good. Let's go along with before assigned bench. Yes.
146.
Non appears.
147.
147, Your Lordship, and for the petitioner, Your Lordship, I have no instruction. I will get instruction within a week, Your Lordship, from the petitioner, Your Lordship.
We have
No instruction.
so-called affidavit. The order of the honorable court has been complied and the date of the retirement age has been enhanced.
Therefore, you don't have any instruction. No instruction. No instructions.
148.
Student counsel for the petitioner states that he has no instructions to press this application. It has been stated by an AGA that this court's order, violation of which has been alleged in the present contempt application, has been fully complied with.
I am for number 2 minutes.
Contempt application stands dropped. Right. Contempt proceeding stands dropped accordingly. Yes.
148.
148, I have no instruction.
No instruction.
Also, the order has been complied and the demarcation procedure.
149.
Notice has issued, so far has not been filed.
What is this? What is the order?
The order was valid for a direction was given to the Tahsildar to take action regarding eviction of unauthorized encroachment of a goods and land.
Where is that order?
That order dated 14/11/2017.
Where is the order?
The day encroachment proceeding was registered And the process for eviction was initiated, and in the meantime, the K form has already been issued to the person concerned. That is the instruction.
No, there is no contempt. The petitioner has alleged disobedience of this court's order dated 4/11/2017, passed in WPC number
Second contempt order, this is second contempt.
443 of 2017 and 5/5/2018, passed in CONTC number 552 of 2018. Stop. The writ petition filed by the petitioner was disposed of with a direction to the Tahsildar Jatni to look into the petitioner's grievance as made in Annexure 6 in relation to unauthorized grievance to the effect that a gochar land as well as government road which the petitioner used for ingress and egress was encroached upon by private persons. Getting sentence. Nine sentence. Sentence. Stop. Learned counsel appearing on behalf of the petitioner has submitted that till date no action, no concrete action has been taken. Stop. It has been stated, however, on behalf of the contemptors that proceeding for removal of encroachment has been initiated.
Initiated by the encroachment case number 226 of 2017, and K form so cause has been issued.
And so called notices have been issued. Stop. In such view of the matter, no case of deliberate disobedience of this court's order is met out. The petitioner shall be at liberty to appear in the encroachment proceeding. But what can you do? In such view of the matter, in the court's opinion, no case of willful disobedience of this court's order is met out. Contempt proceeding is dropped.
Item 150.
It is similar to 147.
Order
Here
complied.
also the decision has been taken for enhancement of the retirement.
147
is 59.
147 line disposal.
So cause affidavit also already filed regarding compliance.
And in which 147 has been disposed of.
Yes, ma'am.
Yes.
Same.
May I tell you?
147
No instruction. Here also he does not have any instruction.
Yes, sir. Legal oblige. 151.
151 also might not complied.
On appeal from beyond the petitioner states that it has been complied with.
152. One 52
No.
152 one is
No.
153.
Let's page 15. What's direction was in for page 15. Considering the limited request involved in the matter, particularly seeking direction against the OP number 1 to work out the direction of OP number 2 within a stipulated period of time, this writ petition stands disposed of with a direction to the Tahsildar Berhampur OP number 1 to work out the direction of OP number 2 within a period of 2 months, provided there is no legal impediment otherwise. This was not carried out.
Now, where is the order? Where is the order?
Order is 13/2/2017, my lord.
Where is the order in the application?
It's in page 15, my lords.
Page 15.
Page 15. The contempt petition.
So,
These are not the orders to. Yes, what is your instruction?
They have not received the instruction. But you may keep it next week.
The writ petition was disposed of on the very first day when the matter was taken up without notice. On the very first day. Was of and disposed of on 13/2/2017, violation of which is being alleged in the given contempt application. The writ petition was disposed of with a direction to the Tahsildar to work out the direction of P number 2. Who is OP number 2?
OP number 2 is the sub-collector, my lords.
P number 2.
That's the sub-collector.
OP number 2, comma, the sub-collector, comma, if there was no legal impediment. Stop. The
Another contempt was also filed.
Considering the nature of the order issued by the court as noted above, comma, in the court's opinion, no case of in the court's opinion, no proceeding for deliberate disobedience of this court's order is required to be initiated. Stop. Sentence for no. Required to be initiated. Contempt proceeding is dropped.
154.
154, my lord. Let me come next Friday. I will take instruction whether the order of the.
What is the order?
Order of disposal of the representation.
The representation dispose of.
Basing upon the proclus of case.
Huh?
Basing upon the proclus of case. The disposal representation.
Yes, what is your instruction?
No instruction has been received. No instruction received.
As requested on behalf of the contender, I will parties list this matter on 1 week.
1 week.
155.
155, my lord, already complied. My lord.
No one appears complied with as stated. Because
Item 156.
156 also complied.
same answer, yeah, na? No one appears on behalf of the petitioner. Then PGA representing the contenders submits that the order has been complied order of this court, violation of which has been alleged in the present contempt application has been complied with. Drop. The contempt proceeding stands dropped accordingly. ये एक nature का order है, समझ में?
Item 157.
No one appears, dismiss for default.
158.
Not complied, your lords.
What is the order?
The order is, I have quoted it, my lord. Subsequently comes to page 5. Page 5 of the contempt application.
Page 5.
Sorry, my lord, sorry. The page 4, my lord. The relevant portion is as page 4, my lord. It was directed to dispose of the demarcation case by the Tahsildar. It was the direction to dispose of the demarcation case filed by the petitioner.
Where is the order passed in the writ proceeding?
It is page 4, your lordship. I have quoted it, my lord. Page 4 of the contempt application.
Just a minute, just a minute. Item?
It starts from page 3. The relevant portion is
Just a minute,
page 4.
just a minute.
Plus.
Yes. Yes. Yes.
But it is not on.
Your Lordship may kindly have a glance to the so-cause affidavit. 5, para 6 of the so-cause affidavit. The date for demarcation was fixed to 6/4/2018. RI was instructed to conduct the demarcation, but the parties didn't turn up on that day. And subsequently, another date was fixed, and thereafter there is no further instruction.
There is a so-cause has not been served, my lord.
There is no order at all to be implemented.
It was directed to dispose of the, my lord, the demarcation case.
If there is no legal impediment, we don't know what is the legal impediment.
My lord, let them serve the copy of the so-cause so that I can go through that.
WPC number. So and so. WPC number 2066 of 2017 was disposed of by this court by an order dated 10/3/2017 with a direction to Tahsildar Puri to take steps for disposal of demarcation case number 35 of 2014 as expeditiously as possible, preferably within a period of 4 months from the date of receipt of certified copy of this order, if the same was still pending and quote unquote there was no other legal impediment. So it has been stated by learned counsel representing the contemners that after this court's order was passed, steps were taken for demarcation of land, but the parties did not appear. Parties did not appear.
Did not turn up on that day.
Did not turn up on the date fixed.
Then subsequently another date was fixed.
Thereafter, next, in the court's opinion, there was no such positive direction issued by this court, violation of which can be said to be constituting contempt of this court. First off, the order was conditional, subject to any legal impediment. First off, in such view of the matter, the contempt proceeding is dropped.
Item 159.
Non appears.
Item 160.
Non appears.
161.
Non appears.
I am for the contempt. The order has been completed.
Non appears. Contempt. Appears. State that the order has been complied with.
162.
Non appears.
Other 162, here a writ appeal was pending, that is the so-cause affidavit last filed. WA number
Non-appears.
484 of 2008.
Case admission 163.
I am for the petitioner, my lord. My lord, order dated 31/10/2008 in the writ petition not carried out last occasion. My learning friend for the state asked for an extra copy. I served on him, my lord. There is a
What is the order?
Order I have quoted in paragraph in Contempt petition, page number 4, paragraph 6. The concluding direction is, my lord. Next page, paragraph 3. In the
Let me see.
my lord,
Let me see, where is the order?
my lord, my contempt petition, page 4, quoted in paragraph 6. My lord. Next page, the direction is to opposite party number 1, the Public Enterprise Department, Secretary, to pay the dues within 6 months, my lord. I was voluntarily granted retirement from 31/5/2001, and partly some payment were made and some were not made. In a writ of batch of writ petition, this honorable directed the opposite party number 3 management to compute the dues and to pay within 6 months. They didn't pay, my lord. Though my name appears in the list, I have been admitted dues. Arrear wages 72,500.
Mister, you filed a writ petition in 2007, which was disposed of. Earlier also, you had filed a writ petition in 2023, which was disposed of in 2006. So you filed 2 writ petitions for the same relief.
No, my lord. First, my writ petition was 18.
All right, who is paying for the other side?
State OP number 1, my lord.
And where is the order passed in this case? Order dated 18/3/2006?
That is where, my lord, in the running page 31 of the brief, my lord.
31.
My lord.
But the binding
31 is of what?
That is copy of the judgment, my lord.
Which judgment?
The earlier batch of writ petition, where I was also a party. I was a writ petition.
my lord,
You have annexed that with what? Your contempt application?
No, no, no.
And
That is 31 is, that is OP3 was enclosed.
so
these are winding up proceeding. No?
Flag D.
Yeah,
where is the direction?
Direction is in the last paragraph. Page, brief page 39, internal page 15. I accordingly direct that all the benefits promised under the BRS and BS scheme as the case may be, if not paid to the petitioners, be paid within a period of 6 months, and the records of the
Who
industry.
is paying for the other side?
That the winding up proceeding of the company, Vaskar Textile Mills, was taken up before the National Company Law Tribunal. Now the company has been wound up and the official liquidator has been appointed.
Then what can be done here?
My lord, this is the order passed by the.
Nothing can be done here.
So he has to raise the claim before the official liquidator.
My lord, what? 23 years already passed.
Nothing can be done.
Again, 23 years.
Nothing can be done, Mr. Officer.
State, my lord.
Huh?
State.
State.
My lord.
State.
There is a direction.
You are working under the state.
My lord, OP1 has been, BRS scheme was sponsored only.
You were working under the state.
No, under the state-owned corporation.
Under state-owned corporation.
My lord.
Corporation was what? Was it a company?
My lord,
Was that a company? Was that a company?
My lord, that is a state-owned registered company. Well, just a minute, my lord. The management has no funds. State government decided and introduced a retirement scheme, and whatever dues paid was paid by the state government. And the area dues, I should go for liquidation and wait for another 20 years. If your lordship feel it is justified, your lordship may directed accordingly. I will wait. Some of the other spinning wheels, my lord, the similar questions arose and the matter went up to Apex Court. Apex Court directed the state to pay the dues within the.
Apex Court can do that. Apex Court can do that.
I have a
Apex
copy
Court-
also.
All right, Apex Court can do, Apex Court pass that in which proceeding?
And your lordship have a glance of it.
Yes, yes.
I want justice and that too substantial justice.
Justice, substantial justice, that can be done under bond.
Your lordship feel, your lordship may direct. I am also fighting and being tired, my lord. 2001, I retired. So maybe 80,000 rupees they can pay and they can take from the liquidation.
So this is your complete answer. This order is your complete answer.
But direction was to pay the state.
Direction.
And the state also paid, my lord.
Mr. Counsel, this order was passed by the Supreme Court in exercising power under 142.
Now, basing upon that also, our honorable court also passed direction in a writ petition. I don't have extra
The writ
copy.
petition cannot, such order cannot be issued. Very good. This is what, in view of the order already passed by the Apex Court, this petition stands disposed of.
He has quoted the,
Very good.
honorable single bench has quoted that order. I will leave it to your lordships.
The court is helpless.
Again, liquidation they will take 20 years. There will be tender, and the tenderers will also fight for the road, for valuation.
The petitioner was working where? You are working where?
Bhaskar Textile Mill, one state textile corporation.
In Bhaskar Textile Mill, owned by the owned by the Odisha State Textile Corporation.
Corporation Limited. Owned by the state government.
The said state-owned company is admittedly under liquidation. Stop. Liquidation proceeding began when? The petitioner in the present contempt application has alleged
Last writ petition was disposed on 18/3/2006.
disobedience of
And then on
order of this court dated 18/3/2006, passed in WPC number
10837 by 2003.
10837 of 2003.
837.
The 10837 of 2003. Stop. By the said order, batch of writ applications were disposed of with certain directions. Stop. The petitioner had filed another writ petition.
My lord, in between that, the OP number 3 decided my claim on 4/8/2006. Then I filed the second writ petition.
The petitioner had filed a second writ petition giving rise to WPC number.
That is 16410 by 2007.
16410 of 2007.
After the finalization of my dismissal.
This court noticed the circumstance that the petitioner had earlier approached this court and disposed of the writ petition, disposed of WPC number second one. In terms of the court's order dated 18/3/2006. Stop. It is not in dispute that the said corporation in liquidation. Stop. Land counsel appearing on behalf of the petitioner has drawn the court's attention to an order passed by the Supreme Court in SLPC number 354-355/2009. Dated 21/3/2017, which reads as under. Oh, quote कर दो. Yes. Where is your spinning wheel in this case?
No, other five similarly placed spinning wheel in the state.
And how will this order apply in your case?
That is state owned spinning mills, my lord. That is the
Sorry.
five listed is there.
As the company is under a liquidation, comma, in the court's opinion, no case of deliberate disobedience of this court's order is made out. Stop. The contempt proceeding stands dropped accordingly. Stop. The petitioner shall be at liberty, however, to approach appropriate forum for the redressal of his grievances.
Liquidator, liberty may be given to liquidator.
No, any forum. Where is the order which has been violated?
That is Annexure 1 and 2. Annexure 1.
Annexure 1 is contempt petition.
Actually, in this case, I am not prepared. It may come next week. Mr. Amyo Kumar Mahanti, actually, he is the conducting advocate in this case. Page number 6.
No, but where is the order passed in the writ petition? Yes, have you filed any reply?
And here earlier in 2011, a so-called affidavit was filed that revised pension papers after corrections were created. And the revised pension papers have been submitted to the controller of accounts. In 2011, this so-called affidavit. Subsequently, whether the pensionary benefits has been released or not, that is not on record. Well,
As jointly requested on behalf of the parties, list this matter on 2 weeks.
165.
Already complied the order.
Complied with.
165 Millard, they have partly complied. The direction was to issue a corrected mark sheet. They have not issued. They have only, after the lordship's order, they have passed a corrigendum only. They have not even intimated to come and take the certificate.
Where is the order?
Order is, your lordship, order is page 9 of the operative procedure 8 and 9. 1st February 2011. Page 9 of the content petition. Issue a face provisional certificate from mark sheet mentioning the date of publication of result 16/11/2009. So they have to issue mark sheet. Certificate from mark sheet.
Already corrected market date 16/11/2009.
Lordship direct them to issue. This petition was declared fail. Thereafter, he passed after correction. The first division student.
Yes, you have you done it?
Already corrected is 16/11/2009.
It is stated by, yes.
Yes, they are now stating that they have not communicated. They have only sent by post this corrigendum without even intimating to come and take, because the petitioner is residing 400 kilometers away. So let them confirm so that.
See this contempt petition of 2011.
Yes, yes.
And it has been done in 2024.
After the lordship.
You are waiting for
No,
2035.
my friend is happy. I am for the petition. Writ appeal was there. That is why we have to wait. Writ appeal they dismissed, that thereafter they are now limiting by virtue of your lordship's order.
It is stated by learned counsel representing the contender that corrective measures have been taken in the light of this court's order dated 1/2/2011 passed in WP C number 1453 of 2011 by issuance of a corrigendum as regards the date of publication of result as 16/11/2009 instead of 37/2010. Stop. Next, learned counsel appearing on behalf of the petitioner has however submitted that the petitioner has not communicated about this decision. Petitioner has been communicated.
Corrigendum they have communicated.
That the corrigendum so issued by the contemners has been received by the petitioner. But the provisional certificate cum mark sheet mentioning the date of publication has not been issued as was directed by this court. So stop. Next, since the corrigendum has been issued in terms of the observations made by this court in the order dated 1/2/2011, I am of the view that no willful disobedience of this court's order is made out, requiring this court to proceed further in the present matter. So stop. Yes, what do you want?
Only they have to issue the certificate.
It goes without saying that if the petitioner approaches the controller of examination, Sambalpur University, for issuance of provisional certificate, they cannot do it. You will have to use that corrigendum with your mark sheet.
There is a direct, they have to correct the date and issue. That is a direction. They give it, I have to give the vote. I will get it physically. They have already published.
Provisional certificate with the corrected date of publication of result, the same shall be considered in accordance with.
They have already, they have already filed the corrected, but I have to get the original only. In the
Then what is?
Here they have filed the Xerox copy of that corrected certificate.
It has also been informed that corrected provisional certificate of mark sheet has already been issued, a copy of which has been brought on record by way of a record by way of an answer to the so-called reply filed on behalf of the contender. So, the petitioner shall be at liberty to obtain an original copy of the said certificate from the university. Contempt proceeding stands stopped accordingly.
166. Page 3, the order is quoted. I have also given a certified copy for your lordship's perusal. Page 3, third paragraph of page 3. The direction is there for payment of the retirement benefits. If I may place that.
Page 3.
Page 3.
Yes.
Paragraph 3, considering the submissions made and keeping in view the letter issued by Card Bank Sonpur and the letter of the MD Oscard Bank.
But this has not been complied with.
It's not been complied. They had filed show cause affidavit also, saying OP number 4 says one will pay, one says I don't have the money. The direction is towards.
What is Card Bank?
Card Bank is Credit Agricultural and Rural Development Bank. I'm sorry, Cooperative Agricultural and Rural Development Bank.
Who has to pay?
The direction is OP numbers 1 and 4.
Who is OP number 1?
OP number 1 is Card Bank and OP number 4 is Oscard Bank. The Orissa State Cooperative Agricultural Rural Development Bank.
So notice will have to go then.
Notices have been issued. They have filed their replies.
The bank is represented by one Mr. Dinesh Kumar Panda. His name appears. Not there. They are represented by them.
Both banks have filed their replies.
What is their stand?
Now, OP number 1 says that the dues are legitimate and has asked OP number 4 to pay. OP number 4 says that OP number 1 has to pay. That my lord would see at flag A, the reply of OP number 1 is there. Flag A, show cause on behalf of OP number 1. And relevant would be paragraphs 3, 4, and 5.
What is this Card Bank? Rural Development Bank? What is that?
Cooperative Agricultural Rural Development Bank. And the reply of OP number 4 is at flag B.
You were employee of what?
We were employees of this Oscard Bank.
Oscard?
Yes. Now,
Oscard card involved in this case.
Oscard Bank is the apex body. Under that, Card Bank operates. Now, Card Bank says that your dues are all legitimate, but we don't have the funds. It is Oscard Bank which will pay the dues in this show cause. Now, Oscard Bank says that we have paid whatever money was due to you, you pay. So that is so between both of them, now they are discussing since 12, 13 years.
No, but you were employee of
We were employees of Card Bank.
Card Bank.
Yes.
So Card Bank, whether it exists or not.
It exists. In fact, the show cause says that this amount is due, but the Oscar Bank has to give us this money for us to pay. And Oscar Bank says that you pay from whatever money you have. That's the basic.
Who is the contender?
We have arrayed both of them because the direction is vis-a-vis both 1 and 4.
Oh, what is his name? Oh, Card Bank.
Now,
Let us confine to Card Bank.
Card Bank,
the opposite parties.
At that point of time, it was Manabodha Bhoi, the OP number 1, by name he has been arrayed as a party.
Was the managing director?
Yes, ma'am. And MD of Oscar Bank is Gopabandhu Satpathy.
There is no representation on behalf of the contender. Though contemners, though they have entered appearance. So stop close this case on next Friday. Stop if on the next date. The court finds no representation on behalf of the contenders. Direction for personal attendance of Uspoka. Let the present managing director of the Card Bank be implemented as opposite party in his individual capacity. First off, let's this case on. Next week we will see.
Grateful to you.
167.
167 already complied with, my lord, and FTD is already in filed.
No one appears. Leonard DSG states that the order has been complied with. The proceeding stands strong.
168, sir.
My lord, the order starts from page 15. The operating portion is at page 17, my lord. Your lordship can have it at, it's right. The paragraph 7, it starts from page 16. In view of the above facts and circumstances.
Just a minute. This is 1704.
My lord, this is
170.
170, my lord. Direction was given, and also on the last order, my lord, 21st of June 2024, the state was asked to file about this.
No, where is the order? What is the order?
My lord, the order is, I'm placing it at page 16, paragraph 7, my lord. In view of the above facts and circumstances, we dispose of the writ petition with a direction that steps should be taken by the university authorities as well as by the state government to regularize the services to the petitioners as expeditiously as possible. It is needless to say that if necessary recommendation is made by the university authority to that effect, the same shall be considered with a pragmatic view following the ratio of the judgment of the Honorable Supreme Court in the case of Omadevi as well as UP State Electricity Board, Supra, and necessary orders shall be passed in accordance with the law. The university has filed a counter stating reply that they have recommended, they have asked the state government for creation of the post, and the state government has not created. As a result of which, your lordships have passed order on 25th of June 2024, asking the state government what action they are going to take or what action they have taken. They have to give a reply that they have not signed.
Yes.
The instruction I have not received. Well, actually, keep it to next week.
Next week, as requested on behalf of the contenders by AGA, is this matter on? Yes,
Item number 169. May I please, your lordships. On payment of retirement benefits. The state was directed to take instruction on the last date. And here the Board of Secondary Education is the contender. And they are represented by their own counsel, Mr. S.S. Rao. He has to appear. It's not. I'll serve a copy, your lordship.
Serve a copy. Let a copy of the contempt petition be served on learned counsel representing the which board?
Board of Secondary Education.
Board of Secondary Education, Odisha.
Odisha, your lordship.
Odisha Board of Secondary Education. Must have placed this matter on 4 weeks.
170. Calling after 4 weeks, your lordship.
Yes.
Sir, kindly glance to order dated 28/6/2024, my lord, sir.
Yes.
28/6/2024. I requested on the additional loan advocate for the opposite party contender is granted 2 weeks time to seek instruction and inform the court as to whether the order of this court violation of which has been alleged in the present contempt application has been complied or not.
Yes.
Here I have not received the instruction, your lordship. Next week.
Who was required to comply with?
My lord, the opposite party, one, my lord, that is Secretary School and Market. Commission come Secretary School and Market.
Lordship,
And what was the order?
Order, my lord, sir, to dispose of the representation.
No, dispose of the representation, please.
my lord, it must have been done in the meantime. I'll just.
Humble request.
My lord, it has been, it must have been done. If not done, it will be done by your lordship. Keep it to next
This
week.
matter on 1 week. Learn AGA to seek instructions as regards compliance of this court's order. The same order was passed on 28/6.
My lord, I have not received the instruction. It will be done, my lord. If it
Then
not-
I'll make them send you instructions.
No, I'll ensure that it is done, my lord. Friday. Lordship, keep it to next Friday.
Next Friday.
171.
Please to your lordship, Miller. Here is the contemner is Balasore District Central Cooperative Bank. Contemner is Balasore District Central Cooperative Bank. Earlier notice and your lordship turn to order dated
What is the order?
21/5/2024. Fresh notice issued to the secretary.
What is the order? Let
Order
me
here.
see.
170.
Order passed on page 5 the contempt petition. Page 5.
Yes.
Page 6 here also kind. Page 6.
Yes, I have seen. Who appears for the other side?
My lord, the present opposite party contender has been replaced by another person by the order dated 5th August 2019. But still then my name is in the court list, it is not deleted from the court list.
So that the present, now the present secretary, your lordship has issued notice to present secretary on 21/5/2024. Notice issued, they not actual, but another thing, my lord, I have also take instruction from my client, but in the meanwhile, whether the order has been complied or not. So 2 weeks time may be allowed, because there is some area views. So your lordship may allow 2 weeks time.
No, the simple direction is that in view of the above, the dispute forthwith. So the order of the tribunal was required to be implemented. Where is the order of the?
In the central,
Where is that order?
tribunal,
Where is that order?
that order, my lord, I have not annexed in the,
Then the order is based on that.
yes,
Then what for have you filed contempt?
because the order is already quoted in that, order of the criminal code, my lord. Page 5 and 6, my lord.
Order of the tribunal has been
Order
quoted.
quoted, my lord.
Where?
Page 5 of the contempt petition, my lord. Only question of the question from 80 to 2009,
Very
the
difficult.
suspension,
Where is page 5?
page 5 of the contempt petition, my lord.
Page 5 of the contempt petition.
my lord. That is order, my order dated 2/4/2013.
2/4/2013.
13.
This is passed by this High Court.
Yes, my lord. Or that
Where is the order passed by the tribunal?
tribunal part, that the brief fact is there, my lord. This is the fact is there, the order of the tribunal already quoted in this, my lord.
Sorry. The
So, my lord, by the 2 weeks time, that whether the order already complied or not.
sorry, this matter is pending for last more than a decade. The
This is the order, my lord, your lordship kindly see.
where is that order?
This is it.
No, I will not see.
I'll file the appeal with my.
You may do whatever you want. The petitioner has raised disobedience. Right.
Order already complied. So I have to take instruction
Related.
from the party and file the affidavit before your lordship's question of the regarding compliance.
Disobedience of an order of this court dated 2/4/2013, passed in WPC number 12587 of 2011, which was disposed of with a direction to the opposite party to comply with the order dated 19/2/2009, passed by the Cooperative Tribunal, Odisha, in service dispute case number 3 of 2004, forthwith. First off, the order of the Cooperative Tribunal, Odisha dated 9/2/2009 has not been brought on record. First off, the petitioner has no instructions as to whether the court's order has been complied with or not. First off, in such view of the matter, the present contempt petition proceeding stands dropped. Yes.
172. May. Your lordship directed to issue appointment order after questioning the termination order, my lord. Your lordship has directed this honorable court after questioning the termination order, directed to reinstate the petition in his service.
Where is the order?
Order, my lord. Order dated 21/1/2013, my lord. Order page 5, my lord.
Page 5.
Operating portion, page 7.
Yes.
Considering page 7, considering the rival submission of the parties and keeping in the decision rendered by the division bench of this court as well as of the apex court as above, this court questions the impugned orders dated 12/10/2007 and
You are continuing as Shiksha Sahayak.
and directs the opposite parties 1 and 2 allow the petition continue in service as Sikha and extend her all concerned benefit. Last time, lordship director, my lord, take instead whether that order has been complied.
Here, my lord, a Soko's affidavit is filed in 2015. There, a ground has been taken that a writ appeal was pending before this honorable court in WF 479 of 2015. The present status of the writ.
As per my instruction, that writ appeal has been dismissed.
Your lordship may call it next Friday.
Next week. As jointly requested.
173.
173. No one appears.
Item 174.
Appearing for the contender who was posted there on 31/7/15 to 25/6/2016, my lord. Where, my lord, he has relieved from
You are for the contender.
contender. My lord, that contender have been relieved on 25/6/2016. And they have not made party to the present incumbent or after 2016 any incumbent, my lord. Therefore, I have no power in this case, my lord, after his transfer, my lord.
That's not correct. Your lordship can see, I have made party to the special officer Saura Development Agency. Saura special officer has been made party.
A special officer cannot be a party in a contempt proceeding.
And that at that point of time, there was the officer was not posted there.
False item.
So the agency was
That party. You'll actually kindly see the order. Order was passed in 27/2013. Directing to allow the petitioner to continue as life after comes before.
Just a minute. Where is the order?
Order that is, I have mentioned in my contempt petition para 2, will actually connected with 27/8/2013.
Where is that?
That in the, I have mentioned in my contempt petition paragraph 2.
Paragraph 4.
Paragraph 2, madam. That directing issuance of notice to opposite party in the said order, this announcement was pleased to direct that the special officer, Solar Development Agency office, the present concern shall appear before this annual court in person on the next day on 20.
Where is the order passed by this court?
Then that is, well, actually, I have not annexed. That is the correct.
You have not annexed, you have not quoted. You have described the order. And you want the court to proceed on that basis.
That you are, that is to pass in the connected read.
What was the order? Let us understand.
Yes.
In my.
Just a minute.
27/8/2013.
Just a minute. Just a minute. Where is the order? In this paragraph?
In my soap also.
So the writ petition is still pending?
Yes.
Yes, madam.
Very good.
And they are not allowing me to continue last 11 years. now.
Matter along with WPC number 14204 of 2013 before the assigned bench.
175.
May I please to fix any time limit for this?
That will be listed.
Yes.
See, it's a peculiar situation that you received an interim order in 2013
Thank you.
and in 2000 till 2024 your writ petition has not been disposed of, has not been taken up.
And twice in the contempt petition, you
As in the contempt petition, you are depending on contempt petition, you are not pursuing your writ petition.
no, writ was pursued, and the state government has taken time twice and they have not filed counter till today.
All right, that will be seen.
Item 175.
In this case, the petitioner he will transfer from other to Cooperative. There is some need of affidavit. I have information will come by
Let me see where is the order first.
Sunday.
Representation disposal, yes?
Odisha University of Education and Technology.
Huh?
State government is another party Miller. Odisha University of Agricultural Technology is
Which item?
175.
What was the order? The registrar was directed to file, to decide, consider and dispose of your representation. Well, in 2013-14, the registrar was directed to consider your representation. That is the order. It has not been disposed of.
the director, the register of the OUT, he did not do things, but due to filing of this case, they were transferred me to one place to another. With that,
That can be done. Whether your representation has been disposed of or not.
that Sunday will come. It will come next for Friday, so that I'll give the details.
By order dated 7/2/2014, the registrar of Orissa University of Agriculture and Technology, Bhubaneswar, was directed to dispose of a representation which was filed by the petitioner as expeditiously as possible, preferably within a period of 2 weeks. Learned counsel for the petitioner does not have any instruction as to whether the said representation has been disposed of or not. So he has submitted that the petitioner has been transferred to another place which action is punitive in nature. So, since the contempt petition was registered in 2014 and the petitioner has no instruction as regards disposal of a representation, I am not inclined to proceed in the present matter any further. Contempt proceeding stands stopped. Yes.
Liberty may be given to the petitioner. In cause of action,
If the petitioner has any fresh cause of action, he will be at liberty to approach appropriate forum in accordance with law. Yes.
176. Order complied.
Non-appears order.
Order already complied.
Yes.
177. 177 order complied.
Compare.
178 order complied.
Non-appears.
179
Complied.
order complied. 180
Non-appears.
181
My lord, on the last order, can you be seen?
My lord. May I please your lordship, my lord? I am for the opposite parties, my lord. Actually, I ceased to be a counsel for FCI. I have intimated them to engage some other lawyer. If your lordship kindly grant 1 week time or so that it will be possible for them to engage other lawyer, my lord.
So where is the order?
Minus, the order minus can get it at page. It's the operating portion minus, the page is 15. It starts from this paragraph. Paragraph 19. The opposite parties being a public sector, it is not expected that the public sector maintaining 2 sets of date of birth, and further assuming that the petitioner was passing a maturation certificate, and the maturation certificate was reflecting the date of birth of the petitioner. It was 29/3/1954. In no circumstances the opposite parties could have maintained the date of birth of petitioner 29/3/51. In contrary to the recording in the board certificate. Please further establish from the beginning of.
But what is the order?
Minus that order is that last 4 paragraph, last 4 lines, minor. Consequently, that paragraph last 4 lines. Consequently, the petitioner's date of retirement also be treated as 31/3/2014 for all purposes thereby. She may be granted all service benefits treating her to have been retired from the service on 31/3/2014. Then according to direction was given. They are not complex. On the last occasion, your lordship wanted to know, checking with whether it has been dismissed. It has not been.
But anyway, if your lordship grants some time, let them appear through some other lawyer.
Members can see I am number 43 of
Just a minute.
2023.
Counsel is.
I have done it the order of the.
And counsel who was appearing for the contenders states that he is no more counsel for them. So stop. List this matter on Friday. Can you do that? 2 weeks, sir.
Asking me. You
Yes.
can engage somebody by Friday.
But I cannot engage. I will write to them. I have already sent a letter, a mail today that the case is in the list. You engage some other lawyer. And so if you grant some time, let them engage.
2 weeks. The matter will come after 2
2 weeks. It will be, sir.
182.
Next week.
Can it today taken up next to thing cover taken up next to the can no, in this case, the Coir Corporation Board has not complied the report.
Yes,
Next to L. Samantra. He was absent. I put taken up next to.
as requested next week.
183.
And I think for the opposite part number 2.
And in this case, we are from the entry order passed by the Supreme Court on 21/2014. That I will be disengaged on 21/8/2015. But the entry order was in 21/8/2015.
So you are already disengaged.
I know.
So a status quo was required to be maintained.
No, I will not get disbanded this 21/8/2015. As per the letter dated 18/8/2015, as a letter. They stated from the month of first, they stated that I will be I will disengage on 30th. And on 30th, I will that there will be no disengagement.
By that time, you were already disengaged.
At that time, no, I have not been disengaged. I will be disengaged. I can see the letter below.
You are appointed to a service provider. We have not disengaged him. The service provider has been disengaged. We have instructed the service provider to disengage. The service provider also is not made a party in the conference. He has been made a party. He has.
This order. I have to make this that control.
Let us pass this order. That is understand.
The petitioner has alleged disobedience of an interim order passed by this court dated 21/8/2015, passed in WPC number 15315 of 2015. Stop. By the said order, by way of interim measure, it was directed that the petitioner may not be removed till next date in the event C was continuing in service. Stop. It is an admitted fact that the petitioner was engaged by the service provider of that is, what is the name of the service provider? Ganesh Info System. Stop. The petitioner was not engaged by the contemners directly. Stop. It further appears that the petitioner was disengaged by an order passed by the service provider prior to the said interim order dated 21/8/2015 on 18/8/2015.
18/8, service provider is disengaged, but we have sent a letter on 14/8 stating that you disengage the petitioner. With effect from
18/8/2015. Stop. By the yes, you submit.
That letter neither has been given to the petitioner, nothing will be given. And the status code was passed.
Who has disengaged you? Who has disengaged you?
But
Who has disengaged you?
The deputy managing director, the Ganesh system, he is established.
He was party.
Yes, my lord. He is party in the writ petition, my lord. Writ petition is in particular.
In the
Direction was not been given to the deputy managing director. Ganesh. He has written this letter to the opposite parties that with effect. My time to see what is the meaning of this letter. As per the letter number 14/8/2015 of the project director DRDA, Bhadrak, Srimati Sulajana Rana.
Mr. Counsel, you don't have the contempt petition with you. Whether this Ganesh was impleaded as party in the contempt proceeding.
No, my lord.
He was implemented as, they were implemented as part. Full stop. Next.
No, the collector and the DRD and also we do. The party.
The writ petition is still pending. Of the disengagement of the petitioner by an order passed prior to the interim order dated 21/8/2015. So,
The stated Vasipur is hereby disengaged with effect from 21/8/2015. Then wrote a letter on 18.
the petitioner was already disengaged prior to service of notice upon OP number 2. First off, in such view of the matter, no case of deliberate disobedience of this court's order is made out. This application is accordingly dismissed. The court has been informed that the writ petition, that is WPC number so and so, is still pending. The petitioner shall be at liberty to pursue the said application. Yes.
184.
184 mal complied.
Compliance, no one appears.
185.
May I please, my lord? My lord? May I audible, my lord?
Yes.
Yes. My lord, order dated 25th March 2014. And till date, no compliance is ever.
Where is the order?
Order is quoted in my petition, page number 4, cooperative person, my lord. Consider the representation and giving opportunity to hearing of the petitioner.
That has not been disposed of. So called affidavit is there. Have you received this clause affidavit?
Affidavit is there, but no compliance is.
Who is for the other side?
And here, my lord, and for the bank contender, my lord. Here I have filed a memo that elected body, pursuant to their resolution dated 21/6/2009, they have disposed of the matter with that she has having adverse CCR, for which her promotion for assistant manager has not been considered. Thereafter, she has filed another writ application 3428/2024. So already I have, the bank has considered the grievance because of the 3 CCR. The promotion for
That has
the,
been done. You have filed another writ petition.
Yes,
So
ma'am.
petition of contempt.
I have filed a writ petition.
After having heard learned counsel appearing on behalf of the petitioner and the contemptor, it appears that the court's direction to consider the petitioner's representation has been complied with, whereafter the petitioner has filed a fresh writ application challenging the decision of the bank.
yes, sir, the CCR that proceeding already,
No, but your bank or what?
yes, bank.
Decision of the bank taken on the petitioner's representation. That decision is on the petitioner's representation.
That CCR, the adverse CCR that has been passed by the committee, that has been checked.
The
That represents is not, my lord. That is the juniors are promoted to supersede me. That is the grievance in earlier writ petition in 2014, my lord. But it is another writ petition which I have filed that is on proceeding, my lord, CCR.
What was your representation about?
Representation is still pending, my lord.
Representation was about what?
About my promotion. To consider the juniors are promoted and supersede to me, my lord. I am senior to them.
Have you passed any order on this?
Yes, sir, that
No, my lord.
by the resolution,
Where is that?
by elected body, by resolution dated 21/6/2019.
Where is that?
That is annexed, that by flag B must have been there, because our flag B
Yes.
with a memo we have filed that I am reading that resolution dated 6/9/2019, my lord. 21/6/2019, taking up the case, Miss Rita Priyadarshini, the committee observed that during the promotion given in the year 2010 to 11, the CCS of the proceeding year.
That is there. Why are you saying? They have brought on record the decision. Has been complied with. Full stop. An extract of the proceeding of the appointment committee meeting has been brought on record by way of memo to demonstrate that the petitioner's representation has been complied with. First off, the contempt proceeding is accordingly dropped.
186. 186 complied.
Non appears complied.
187. 187 also complied.
Complied.
188.
188 no instruction.
No.
189. 189 also complied.
Complied.
190.
Non appears complied.
For the last 8 years I'm fighting, but it has not been complied, my lord.
189.
Yes.
190.
Sorry, 190.
190.
190.
Yes. Where is the order?
90.
Where is the order? 190.
That is in page 3, my lord. I have quoted on page 3, paragraph 3. The order dated 8/12/2015 passed by this honorable being Rehabilitation of council for the petitioner. Petitioner and Mr. D. Nayak and council for the appeal for number 2 and 3 and Mr. S. Misal and additional. Then I am reading the order in person, my lord. In view of the above discussions, the service condition of the state government employee is made applicable to the employees of the Valmi. Accordingly, the retirement age of the said employees should also be enhanced from 50 to 60 years. Operator 2 and 3 have taken steps for approval of the government for the said approval. The court has already considered the similar nature of grievance in the case of Premlata Panda versus State of Odisha and another, reportedly 2015 to OLR 2014. Let the authority consider the case of the petitioner in the light of the ratio decided in Premlata Panda Supra in accordance with the law as expeditiously as possible, preferably within a period of 3 months from the date of communication of the order. Now, my lord, they are making the mention that the Valmi authority is not willing to enhance the age of retirement to 60 years, my lord. That is, they have filed in their counter. They can see about the judgment of this new court, my lord. That is, in October 1, the Valmi was given. Further, the governing council do not agree to enhance.
Mr. Rao was earlier appearing and.
First time appearing was after 2016.
But what, last 8 months I appeared and I've taken, got that file today. But what I optimize from the record is there is compliance affidavit.
Please.
My lord.
There's already compliance affidavit filed that in view of the Premlata case, they have already extended the benefits, notional benefits and everything that has been extended. Already been extended. That affidavit has been filed. Thereafter, my mother filed another objection petition to that. Thereafter, also another reply was filed that he has been compliant. Yeah, 10 months taken up next week, so that I'll go through each of my.
All right, as requested on behalf of the contenders, list this matter on. Next week, let us. Oh, no, 200.
191.
The order letter 21st June 2024, my lord. The order dated 21st June 2024, where my lord and friend was directed to take instruction what is the development pursuant to the show cause filed by the 191, I pray 1 week. I pray 1 week, next week.
1 week, as requested on behalf of contenders.
192.
192, my lord, I may be permitted to appear through VC, my lord. I'm appearing for the petitioner. By the time I have a glance at the last order, the State Council was directed to take instructions about the implementation of the order dated 24th of January 2014. The relevant part is there at page 12 of the contempt application. My lord has page 12.
Yes, you will also call this matter on Tuesday, I will furnish the instruction. By Tuesday.
My lord would kindly see the show cause replies filed by the opposite parties, wherein both of them have taken a stand that they've sent it for this to the state for getting necessary approvals. And those show cause replies have been filed since 2016 and 2019, your lordship. 2016, my lord.
I have seen that 2016, what are the development after you will also call this matter on Tuesday.
Mr. Kutia, these are 2016 matters.
On Monday, you will also call this, I will furnish the instruction.
Means 5 years.
Someone will have to be sent to jail. So I am starting from here.
You will also call this matter on Monday.
I had restrained myself.
Till Monday, you will also.
Let me see whether what was the last order. Yes, this was the last order to seek instruction as regards compliance of the order.
My instruction might be with Mr. Samatra. For that reason, I am praying for Monday. Till
All
Monday.
right. Next Friday.
Gratefully, lordship.
193.
With 193. I am on VC minor.
Yes.
The order dated 9/12/2014 has not been completed. That is under annexure 1 to the contempt application. That starts at page 7, minor. The relevant portion is at page 11, operating portion of the order.
Yes.
8 line from the top. Shall I place the order, minor?
Yes. What is the order?
Order were directed to the BDA to alert the vacant land after taking the money from me. After the order, I filed the contempt application and the order was on annexure 4. This order was directed to comply the order within 2 months. Even after the order, they did not comply. And after my second contempt application, in the show cause they stated that they review an application. And the review application has also been dismissed since 2019, my lord. Till now, they are not complying with the order.
Now I am waiting for some. Yes.
Fact remains, the thing is like this. Urban land, the BDA managers allotted land to the petitioner.
Tell us whether the order has been implemented or not.
That order has not been complied with the unavoidable region, which cannot be, which is completely beyond the control of the Ministry of Development Authority. Fact remains, the order was passed. Their managers, the plot which again his plot, the petitioner's plot,
in course of measurement found that this plot doesn't belong to BDA. That is government land. So BDA cannot allot the land and can sell out the land. That is what we filed a review petition, but by management, this is the contingency in course of GPS measurement, the detailed measurement. It was found out that we have to file a review petition. There is a direction that the review petition copy to be filed to an unfriend. I filed that petition, but in view of the parental order, but the registry refused to send. I filed a miscase to restore it. But the reason that the order cannot be complied with because of the fact that BDA is not the owner of that land. We cannot allot that land.
Where is that review application?
The review application is pending before the High Court. But the review application was dismissed on the technical ground by the registry that we have not sought the copy to be run by one friend, pursuant to the order of the High Court.
So that has been restored.
But in this case, I filed 2 memos I have given. Recently also I have given another memo. I requested management that matter may be listed immediately. The registry is processing it. The consequence is that when this land doesn't belong to BDA, there is a direction. I don't dispute that. But in course of measurement, it was found that the land doesn't belong to BDA. It's not a part of sellable land matters.
What is the number of that?
Review petition matters. Review petition
37 of 2015.
Restoration application.
restoration application matters.
Stop line.
Restoration application, I remember
45 of
How can
2020.
you file a
45 of 2020.
You could have filed restoration application.
I filed restoration application.
Huh?
Mistake of restoration I filed, because that order because it was passed on an unaltered ground, but I have not sought the copy, I sought the copy to my learned friend.
So which matter that will have to be listed that.
That's I have already filed about 2 minutes earlier. But that I want
Details, list karo next. Let's go with this.
I am the detail man, sorry.
Does this matter on, so along with.
Next.
May I comment, my lord? Your lordship may take up- Your lordship may take up the review application along with the content application because in the
Yes, yes.
meantime- in the
In the meantime,
the honorable judge who has passed the order has already been deterred. So your
That is
lordship,
the problem.
so therefore I don't have any, the matter will go.
your lordship can take up the matter
Yes, yes, I know.
so that it can be had on merit.
Thank you, thank you.
Mine.
194,
No instructions,
195.
no appeal.
196,
196, your lordship. I'm seeking for an adjournment, your lordship.
Why? Last time also you had taken it.
The
Hasn't complied with.
it's partly complied, it's not fully complied, your lordship. That's why the client is actually out of station and sees unrolled.
What partly?
See,
What? Which
your
of
lordship,
the order?
your lordship, will file an affidavit. That's
It is for the court to adjourn 2017 matters.
Lordship, for the last, your lordship, for the last
As
time,
requested on behalf of the petitioner, list this matter on next Friday.
the progress to lordship.
197,
On appeal.
item 198,
May I please your lordship, Lord, on behalf of Mr. James Sahu, I already complied with the order.
Complied with.
199,
Lord, on behalf of Mr. James Sahu, I already complied with the order.
Complied with.
200,
But I have for the opposite party order complied with it. I am filing this compliance affidavit.
No one appeals. Compliant affidavit, compliance affidavit is being filed, which is being taken on record. As the order appears to have been complied with, as the order violation of which has been alleged, appears to have been complied with. The contempt proceeding stands wrong. Yes. Yes. No contempt petition, contempt matter today.
201 complied with me, Lord. 201 item complied with.
Complied with.
It's not complied, let it come, let it filed, complied, let's print my.
Huh?
Already filed in 2017, there is a interim direction to.
All right, you are not for the petitioner.
I'm waiting,
Huh?
I'm waiting for 2-3 weeks, I have already complied, that was my.
You have complied with, he is saying that you are not complied with. We will see.
Yes,
So any learned counsel for the petitioner, according to If the order has been complied with,
So item 418.
complied with.
Item 214, my lord, complied. Is it 214? Item 830. Complied with.
Yes, any other matter?
Yes, I may be pardoned, my lords. Last week also, my lords, I had mentioned, and last week also I had mentioned, my lords, the matter which was listed last week, 462, 463, 464, which has been again dropped down to this, today's vote, it is 672, 673, and 674. Yes, it has been partly complied. There was a direction to pay.
At least it has been partly complied with.
There has been a direction to pay 20 months of my area salary. 13 months have been paid. 17 months are yet to be paid by the INPR department, my lords. All right.
One by one.
My lord. Withdrawal. 418, 419. Total memo is there. 418, 419.
My lord.
Arbitration matters, please.
My lord.
Specialist. Specialist stress admission. Item number 1, ARBP 18 of 2024.
My lord.
Yes, the arguments are over.
I am for item number 278.
Let it come next week. Should not. Today I am not in a position to dictate.
I have filed a short note also in.
Next
I have
week.
also filed in the. Oh, bless.
My lord, next week 278.
Item number 2.
No, please, Lordship. Lordship, item number 2, this is a fresh application for appointment of arbitrators, my lords. Plus the arbitration clause is at page, my lords, 53.
Notice will have to be issued.
Plus notice will have to go, my lords.
Issue notice.
Page 52 is the arbitration clause, my lords.
All right. Issue notice.
Item number 3.
Similar kind of matter.
Issue notice.
Item number 4.
My lords. I will BC, my lord. Item 258, my
Item
lord.
4.
On appears next week.
Item number 5. May I please also. And this is the fresh matter. In this case, the arbitration clause is at page 117.
Notice.
May I please?
Pardon, my lord.
Orders item number 6. Item 6.
Lord, here I am for the party members.
But the petition regarding appointment of arbitrator, change of arbitrator.
Change of arbitrator, you will have to wait. Because of that, the Supreme Court's decision and our judgment has not been uploaded. We have not uploaded that judgment because of the Supreme Court's decision. So we want to rehear that aspect. You have seen the Supreme Court's order. Have you seen the Supreme Court's order, the latest order?
I have not.
Must see. Next week.
Item 7.
On appears next week.
Item number 8.
My lord. Due to my leg injury, I was unable to come. Item number 4, my lord.
What do you want?
Sir, appointment of arbitrator.
Yes. So notice will go.
Sorry.
Huh? Press no. So notice will go. Item number 4.
Notice. Item number 8.
Yes, item number 8. Yes, item number 8, notice had been already issued. The state was supposed to take instructions. there is no impediment in appointment of the arbitrators. Lords, as of now, I have not received any counter in this. So I think arbitrator may be appointed, Lords, permitted to be appointed, Lords.
Yes,
You see, Lordship, item 8, can it be taken up next week, Your Lordship? Council, Tarun Patnaik.
all right.
is like.
Next week, Mr.
Next.
Much obliged.
As requested on behalf of the respondents, respondent or opposite party?
Opposite party.
Opposite party, let's this matter on next week.
Item number 9.
On last occasion, your lordship had asked us to suggest name for appointment. Lord, we suggest name of Mr. Ramakant Mahanti, senior advocate, to be appointed if my learned friend
His
appearing.
name is there on the panel or not?
Yes, my lord, his name is there.
Yes. Who's on the other side?
Mr. Kashyap was appearing last time he appeared.
You know that?
IOCL.
He is ill. Mr. Kashyap is ill, my lord, today.
Next week.
I'm grateful, my lord.
Please inform him
I will do.
and seek his consent.
My lord. I'm grateful.
Item number 10. Lordship, in this matter, on the last occasion, notice was issued. We have also filed requisites. No, I have not received any counter. So your lordship may please appoint the arbitrator.
Service. Yes, who is for the other side?
Notice sufficient. Mr. Ellen Patel appeared.
Full and counsel has entered appearance on behalf of the opposite party. He is not present today. First off, discuss matter on Friday. But in the meanwhile, you must have consensus on the name of the.
We have suggested a name already.
So he should also consent to that.
Lordship, we don't know who is appearing.
Huh? You don't know. I will give you
It's published in the
Mr. Lakshmi Narayan Patel.
I'll speak with him. Oblige, your lordship. Item number 11.
Notice has gone, my learned friend is appearing. If your lordship will appoint, my lord.
Oh,
I will suggest Mr. D.P. Nanda, senior advocate.
I have no objection.
Mr. Nitin Nanda. So his name is there. Yes, his name is. His name is there on the panel.
Yes, his name is there in the panel. Hello. Great question. Senior advocate.
Name is not there, sir.
Mr. Ramakant Mahanti.
Ramakant. All right.
Publish. From 12.
Wait, please, please. Sorry, we have and for the opposite party, we have a question. We have intimated the corporation, let it come next week, my lord, we will get the instruction for that.
Can you suggest a name?
I'll consult with my client and get back by the next.
As jointly requested. So as to suggest name of London arbitrator. Let's this matter on next week. Yes.
Obliged, please.
Item 13.
My lord, 3 weeks time may kindly be granted. 3 weeks time may kindly be granted.
Why?
My lord, due to my health issues, actually the ligament injury, I was unable to.
So ligament has nothing to do with arbitrator. All right, as requested 3 weeks.
Item 14.
14, my lord, next week I pray the council is on his legs in Andhra.
The requested on behalf of the opposite party, let's just matter on. 1 week.
No reply has been filed.
Item number 15.
14 minutes, no reply.
It's supposed to remain another time. So let's say 2 weeks time to get the instruction.
No, my lords, 4 weeks too much, my lords. My dues are pending, my lords. I am under insolvency. I am under CIP proceeding is going against me, my lords. 4 weeks is too much, my lords. I was pressing for an order.
2 weeks, my lord, not 4 weeks.
2 weeks, Mr. Council.
2 weeks.
But
My lords,
2 weeks for
no further adjournment should be granted, my lords. That is my only.
2 weeks for what?
For filing of counter.
I seek for instruction because they want the final application for the arbitrator.
So you have not filed your affidavit.
Yes, that's
File it.
yes, yes. That's why I'm seeking 2 weeks time.
2 weeks time. is allowed.
Lords, triumph there is nothing to object to, but anyway, let them file.
Yes.
Specialist. Bail. Additional specialist.
I'm in BC, my lord.
Item number 1, BLAPL 14716 of 2023.
No representation on behalf of the petitioner. 8 weeks.
Item number 2.
Item number,
Next week. Next week.
item number 2, 3, and 6. The accused arising out of the same case, my lord. So that case is under NDPS Act. I pray, my lord, next week I will satisfy also, my lord, last occasion.
No, yes, last time also.
Yes, that is there, my lord. I need only 1 week time to prepare, my lord. I will satisfy also next.
Requested on behalf of the petitioner is this matter on next week. 2, 3, and 6.
Item number 4.
May it please your lords. My lord, here the petitioner in conspirations, my lord, 12th January 2024, my lord.
12th January 2024.
24.
What is the offense?
My lord, 395 and 2527 of the Arms Act, my lord. The highest, 400, section 400, 457, 458, 395, 398 of IPC, read section 25 and 27 of Arms Act, my lord.
Yeah, antecedent.
Antecedents, my lord.
17, Miller.
My lord.
Sorry.
But my lord, in the rejection of the lawsuit comes to page 16, my lord. On part ground, the learned court below has rejected my bill application, my lord.
No, that is, you are not challenging the order.
My
You are not challenging the order.
lord, those antecedent parts, my lord, out of 17 antecedents, 15 cases are of the period, my lord, 2013 to 17, my lord.
That is immaterial. Because from
And in
period
no
2000
case the petitioner has been convicted.
there can be two circumstances, more than one circumstance. One, that you were continuously committing crime between 13 to 17, and thereafter, because you might have been taken into custody, there was no further crime committed by you after 2017.
In all the cases, my lord, is in bail, my lord.
Therefore, you must have been in custody for quite some time,
My lord.
and therefore there is no antecedent.
I got my lord, but The petitioner, my lord, is moreover the
If you want to stay safe, then you should remain in jail. Otherwise, the moment you come out of jail, you will again be, implicated in some false case.
moreover, my lord, the petitioner is a young boy, my lord, 25 years young boy, my lord.
Sorry. Young boy is adult now. Yes. The
My lord, the
application
not raised, my
and counsel for the petitioner after some argument.
liberty may be granted
This
to
is
access
not
the
to
court below.
raise this application. Application is accordingly dismissed as not raised. So stop. He shall, however, be at liberty to renew his prayer for bail after 6 months.
My liberty may be granted to move before the court below, my
Why?
charge sheet has been submitted, my charge sheet.
Therefore, you can move anywhere. Not before 6 months.
My obligation.
Item number 5.
On PS. What is the offense?
NDPS matter, copy of billet.
No one appears. Cited. Yes.
Item number 7.
Number 7 may praise the Lordship. Here, petitioner is like a young boy, 22 years old man. He is a fast offender. The young boy of
What is the offense?
offense is my lord, 20B2C my lord. And is the fast offender. Is a
No, that is immaterial.
and
Whether it is covered by section 37 or not.
And he's in languishing in the jail custody more than 1.5 years.
That is immaterial.
And
1.5 years, nothing.
And till today, my lord, trial has also not been commenced, my lord. And to that effect, my lord, here in this case, my lord, petitioner was moving in a, my lord, on a higher basis. The ganja, which 3 persons were traveling. 1 person was those who were sitting in the dala has kept the my lord, ganja, my lord. And
what is the quantity?
Quantity, my lord, 150 kg, my lord. And you will also kindly see for the delay, I am showing the judgment of this honorable court, Supreme Court, my lord. But there is a delay in trial, my lord. So, my lord, taking into consider the family condition as well as all the, because it is under special act, my lord. So, in Muhammad Muslim, it has also been taken into consideration for the delay of trial, my lord. I'm quoted, my lord.
Just tell me which order you are relying on.
Relying, my lord, Muhammad Muslim, Hussain versus State of NCT of Delhi, my lord. I am, my lord, marked the, my lord, observation made by the honorable.
Which paragraph?
Last paragraph, my lord.
Yes.
Where, my lord, scattering of families as well as loss of families bonds and alienation from society. The courts therefore have to be sensitive to this aspect because in the event of an acquittal, the loss to the accused is irreparable and ensure that trial, especially in the case where special laws enact.
Mr. Whether it arose out of section 37.
Yes, my lord.
What is the observation?
Observation is that though there is a, my lord, delay in trial, my lord, and till today no witness has been examined, my lord.
So that was of 2015. In that case, the case was registered in 2015 and the Supreme Court was considering the matter in 2023.
And I have also that 37 has also been dealt with in the Ravi Prakash case, my lord. Paragraph 4, my lord.
No, this will not apply.
And yes, my lord, here in this case, it is paragraph 4, more than here in this case, more 3.5 years. So there is prolonged, my lord, stay in the judicial custody. And in that case, bail was also considered. In another case, my lord, I have given my lord Satendra Kumar until versus Central Bureau of Investigation, where it has been specifically observed that even there is a delay in trial more than 1 year, there should be consideration of bail because the position is a fast offender. having no criminal antecedent, and is a young boy of 22 years, is a driver, entire family members are depending and earning. And that apart, my lord, section 50 of the Act, my lord, mandatory provision has also not been complied. He has not been inquired before a magistrate, my lord. 50 says, my lord, she has also no mandatory provision has also not been complied. And till to the trial, more than 1.5 years in custody. No witness has been examined, my lord. And is a fast offender, my lord.
What this is not in your favor. But this judgment is not in your favor. This is against you. The Supreme Court expressed all sympathy for those who are made accused in the cases under the provisions of the NDPS Act because of Section 37. But what the Supreme Court has said, have you read paragraph 19? So the court has to make observation that prima facie he does not appear to be guilty.
And here, my lord, prima facie, here, worship kindly see. Here, my lord, petitioner is a driver here in the circumstances is that. And another thing, my lord, the learned court below has rejected on the ground that in question of absconding, my lord. He has stated that the
Mr. Please keep in mind that you please don't refer to the order which has been passed by the trial court, because you are not challenging the order of the trial court in the present bail application. This court exercises concurrent jurisdiction. All right. So it is not that you have challenged that order. The lower court rejected your application for bail. Now we have come to the High Court seeking. So we are not required to go into the correctness of that order.
Yes, my lord, but here is a fact, my lord. The petitioner is having no criminal antecedent, young boy 22 years.
Petitioner is a criminal, has no criminal antecedent, is young boy of 22 years. This we have said 20 times.
My lord, here, until today, my lord, Article 21, my lord, till today, no witness has been examined.
That is different. But if no witness has been examined, therefore you are not guilty.
My lord, because the here in this case, in the
all right,
report may be come from.
I'll deal with this. The present application has been filed for the so and so. So
May pray one thing, my lord, stage of the trial may be, report may be called for, my lord, what is the stage? my lord?
Sorry. Now,
Pardon,
since
my
we relied on a Supreme Court decision, I am bound to consider that decision.
Pardon, my lord.
As for also delayed with, in that, my lord, Ravi Prakash case, it has been, this,
Mr. I'm giving you this thing. You make your submissions, complete your submissions, and then allow me to write order. All right. So if you have to say anything, you say.
Yes,
Whatever
madam.
you want to say.
In paragraph 4, in Ravi Prakash was the state of Odisha. It has been, paragraph 4, it has been, as with regard to 37, as regard to the twin condition contained in 37 of the NDPS Act, the learned counsel for the respondents state has been duly had. Thus, the first condition stands complied with. So far as second conditions, reformation of opinion as to whether there are reasonable grounds to believe that petitioner is not guilty, the same may not be formed at this stage when he has already spent more than 3.5 years in custody. The prolonged incarceration generally militates against the most precious fundamental rights guaranteed under Article 21 of the Constitution, and in such situation, the conditional liberty must be override statutory embargo created under 37 1B surplus 2 of the Act, my lord. And this and also granted bail taking into that fact, my lord.
It's all. It is the prosecution's case that when the informant, who is the informant?
The excise, my lord, of course.
Informant, an excise official was performing patrolling duties with his fellow personnel, they detected, they noticed a mini truck moving in high speed. First of the vehicle was detained, and from the said vehicle, a total of 150 kg of ganja was seized from the said vehicle, in 6 bags. Stop. The petitioner was driving the vehicle.
Driver.
Stop. 2 other persons were there, found there in the car. Stop. Learned counsel appearing on behalf of the petitioner has submitted that the petitioner was merely the driver of the vehicle and therefore no offense under the provisions of the NDPS Act is made out against him. Stop. He has relied on the Supreme Court's decisions in case of Muhammad Muslim alias Hussain versus State bracketed NCT of Delhi, rendered on date that
28th March 2023.
what is the date?
Well, on the upper portion, 28th March 2020.
28/3/2023 in criminal appeal number 915 of 2023 and Ravi Prakash versus State of Odisha, dated the date is not mentioned.
Yes, my lord, 13/7/2023.
13/7/2023 in criminal appeal, criminal in SLP criminal number 4169 of 2023. To overcome the rigors of section 37 of the NDPS Act. First off, he has submitted that since the petitioner has remained in custody for nearly 1.5 years and the trial has not commenced, this court should consider directing his release on bail in the light of the aforesaid two decisions of the Supreme Court. First off, next, section 37 of the NDPS Act reads thus. First off, the Supreme Court in case of Muhammad Muslim, bracketed Supra, has taken, after taking note of various Supreme Court's decision, has held in paragraphs 19 and 20 as under. First off, on close reading of the observations made in the case of Muhammad Muslim, it cannot be held that the court, while considering an application for bail for an offence punishable under section under the provisions of NDPS Act and covered by section 37 of the said Act, sentence. Can ignore the requirement of twin requirements of section 37 of the Act, NDPS Act. First off, the Supreme Court has held that satisfaction which the courts are expected to record is that the accused record, that is, that the accused may not be guilty, is only prima facie, based on reasonable reading, which does not call for meticulous examination of the materials collected during the investigation. First off, next, during the first off, considering the nature of allegation emerging from the first information report, I find it difficult to hold, prima facie, that the petitioner is not guilty of the offense. And counsel for the petitioner has submitted that it is the first offense of the petitioner, and he is only 22 years old, and therefore his case for grant of bail should be liberally considered. First off, the said submission has no force and is accordingly rejected. First off, coming to the Supreme Court's decision in case of Ravi Prakash Supra, the Supreme Court has held in paragraph 4 as under. First off, it is not a case where the petitioner has remained in custody for unduly long period of time. First off, he is in custody for 1.5 years, and what is the minimum sentence?
Minimum 10 years.
10 years. And the minimum sentence for the
10 years.
offense alleged is 10 years of rigorous imprisonment. First off, in such view of the matter, I do not find any merit in this application, which is accordingly dismissed. First off, it is, however, observed that the trial court shall make endeavor to expedite trial. Yes.
Pardon, my lord. I am in VC, my lord. Item 258.
All right.
Pardon, my lord. I am in VC, my lord.
Yes.
Item 258. Non-compliance the order dated 29/23, my lord.
All right.
Hello.
That item not called. 298.
258, my lord.
258.
Yes, my lord. My lord, my limited grievance, my lord. Kindly direction may be given to opposite party number 4 to comply the order within the.
Whether the order has been complied with or not.
Not complied, my lord.
All right, it will be taken up later.
Beg pardon, my lord, may I say one thing, my lord, these observation will not, my lord, the learned court below will proceed the trial in accordance with the, my lord, evidence, and not, my lord, influenced by this order.
I have not said anything.
Beg pardon, my lord. Item 477 and 481, my lord. In both the case, personal appearance is there. It is running in list since 4 to 5 years.
So you could have mentioned in the beginning.
It may kindly be listed next week within 200.
देखना personal appearance.
Like that.
You are for whom?
I am for petitioners, my lord.
Petitioner, why are you worried?
My lord, only 2 years services left. Like,
Personal appearance is something else. Your matter is. That's fine.